we are now live and on the record for Wednesday morning's civil docket, March 23rd, 2022. Ms. Edna Cedillo, what do you have?
Yes, good morning. I have number 29 on the court civil docket, and I am standing in for Ms. Lucy Williamson.
Okay, F1362-12-9 in the matter of the marriage of Abiel Sergio Martinez and Elizabeth Martinez.
Isabel Trevino, Your Honor, Office of the Attorney General for intervener.
Your Honor, I was contacted by Ms. Williamson's office yesterday indicating that she would be unavailable today and asked that I urge a motion for continuance. I don't really know the details of the case other than she's requesting more time, Judge.
Okay, and do you know who's representing the respondent?
Your Honor, I did check the court's docket prior to logging on. It looks like he's had three attorneys withdraw. I don't believe he's represented at this time, but I could be wrong.
Okay, so Ms. Williamson represents Ms. Martinez?
Yes, Your Honor, according to Odyssey.
Okay, so Abiel Sergio Martinez, are you present? Okay. Ms. Trevino, any objection to the motion for continuance?
No objection, Your Honor.
Okay, how much time did Ms. Williamson need?
She did indicate, Your Honor, so whatever the court orders, I'll let her know.
Okay.
Yeah.
Okay, April 20th,
I will let her know, Judge.
and that'll be at 9:30.
Yes, Your Honor, and I don't have anything until 11 o'clock, so I'll log back on, Your Honor.
All right,
Thank you, Judge.
thank you. Ms. Cedillo, do you know if that means that her case this afternoon also, she's requesting a continuance on that one?
She was, Judge, and I've been before the court before where somebody's trying to make an announcement for an afternoon docket and the court asked that they reappear. So I told her I couldn't cover the afternoon docket. I don't know. I'm assuming somebody will be here for her this afternoon.
Okay, only because that person's pro se. So I don't have a way of getting a hold of them.
Yes, no, Your Honor. It's my understanding that somebody will be appearing for her this afternoon.
Okay, that's fine.
Thank you, Judge.
All right, thank you. Okay, Mr. Sabo, what do you have?
Judge, I've got two. I'm looking for the docket to tell you the number, but I apologize. I don't have it with me.
Your Honor, if I may, one of the cases with Mr. Sabo is myself, David Solis. It's number 20.
No. The other one is quicker. It's called Garcia versus Beltron.
That's number 10, Judge.
Okay, that's CO 183144-I, Alejandra Garcia versus Gilberto Beltran.
And Mario Cisneros emailed me that he is not available, and I said that's fine. We can pass it until next week, if that's okay with the court.
Okay, that's fine. Let me see.
What?
Let me go ahead and mute this person. Okay. All right, let me see what I have. Okay, do we still have availability on the 30th?
This weekend, is it contested?
Yes. It'll be about 10 to 15 minutes.
Let me see if we have anything at 11 o'clock.
Oh, actually, maybe shorter. Maybe more like 5 to 10.
We should have availability, Your Honor.
Okay. March 30th at 9:30.
Okay, we'll figure it out. March 9:30. Okay, and then I have this one with David.
All right, what number is that one?
Number 28, Your Honor, the status hearing.
Okay, CL 213034-I, Homero Jose Alcocer Jr. versus Adamaris Salinas et al.
Oh. Yeah.
Okay,
Your Honor,
hold on. Please mute yourself until it is your turn to be called. Okay, go ahead, Mr. Solis.
It's just a status hearing. We've exchanged discovery. We already have deposition scheduled, at least of the defendant, and I think we just need another status hearing or preferably a DCC. I don't know if you need to add anything, Frank.
That sums it up. Nope, that's right.
Okay. Are y'all pretty close to getting ready to mediate?
Not real. This has zero chance of settling. It's It's a fight about liability and damages. So,
It's a red light swearing match, Your Honor.
yeah.
Okay, go ahead and file your order setting the DCC. And we'll get you set up for a DCC.
Perfect.
And then it wouldn't be necessary to do another status hearing if you're going to file for a DCC. Just get that in by April the 8th.
I'll get it in, Your Honor. I'll be sure we get it filed.
Okay, anything else?
Not on my behalf, Your Honor.
Me neither. Thank you.
Okay, y'all have a good day.
Thanks. Bye.
Okay, Mr. Banker, what do you have?
Yes, good morning, Your Honor. I'm here on Carla De Leon. It's, I'm not sure where it's at on your calendar, but it's Midland Credit Management plaintiff. And I just have a quick announcement. Since the last setting, we filed an answer on this, and we've made several efforts to make contact with the attorney representing the credit company, and he hasn't responded as of date. I would just like another status, maybe in 30 days, and to see what we can accomplish by then.
Okay.
I apologize, Your Honor. Travis Benz on behalf of Midland Funding. I believe we're talking about Carla De Leon.
Yes, that's number 27 on the court's docket, CL-21-1841-I.
I apologize, Your Honor. For the record, Travis Benz on behalf of Midland Funding. I'm just local counsel, Your Honor, and my only instructions are to request a bench trial date. That's my only instructions.
Judge, I would certainly like to have some kind of discussions with the counsel representing them before we set it for a bench trial.
Okay.
I understand, Your Honor. I'm just local counsel. I'll be happy to give the contact information for lead counsel. I don't have anything beyond that, Your Honor.
That's fine. I'm going to give Mr. Banker the opportunity to go ahead and contact lead counsel on this so that he can discuss the case and see if there's something that can be done prior to getting to that part of the litigation.
Yes, sir. Yes, Your Honor.
We'll go ahead and come back. I'm going to give you some time, Mr. Banker. That way, if for whatever reason they don't want to cooperate with you and you decide to start the discovery phase, that'll give you some time to start it.
Thank you, Judge.
All right, let's go ahead and return on May the 11th at 9:30.
I'll make that clear to lead counsel, Your Honor.
All right, thank you.
All right.
Anything else, Mr. Banker?
No, ma'am, that's great. Thank you.
All right.
May I be excused, Your Honor?
Yes, that's all you have, Mr. Banks?
It is, Your Honor.
All right, no problem.
Judge, may I be excused?
Yes,
Thank you.
okay. Ms. Tania, can you please help me with your last name?
Yes, Your Honor. It's Olette.
Okay, Miss Olette.
Yes,
What do
good
you
morning,
have
Your
this
Honor.
morning?
I am here for Discover versus Laura A. Lopez. It's CL 213784I like igloo. And it's just a motion for default. No answer has been filed.
Okay. Do you know what number you are on the docket?
I do not. I was actually given the wrong information and I was in a whole different court this morning.
Okay, what are the parties' names again?
Discover versus Laura A. Lopez.
Okay, number 23. All right, that's CL 213784-I, Discover Bank versus Laura A. Lopez. Laura A. Lopez, are you present? Laura Lopez, are you present? All right, the name being called out 3 times and no response. You may proceed, counselor.
Thank you, Your Honor. So the defendant was served on November 18, 2021, after we filed our petition for the breach of contract on November the 10th, 2018, after defendant defaulted on the account ending in 257 by failing to make payments when due. Discover accelerated the full balance due as a result of the breach of contract. The plaintiff was served by personal service. No answer was filed, so we filed a motion for default judgment on January 18, 2022. We filed the notice of hearing via regular mail and certified mail to the defendant on February 16, 2022. We asked the court to take judicial notice of the file, which includes the certificate of last known address, the non-military affidavit, business records affidavit, which are all attached to the motion. Plaintiff is requesting default judgment in the amount of $2,550.22 with court costs in the amount of $370.15.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file since November 24th, 2021, has been on file for the required amount of time. Therefore, the court is granting the relief as requested by the plaintiff. And the order that was filed on January 18th, 2022 will be the one that's forwarded to my queue. Okay, anything else, Counselor?
That is everything, Your Honor. May I be excused?
You certainly may.
Thank you. Have a great day.
Likewise. Okay, Mr. Davis, what do you have?
Judge number 32 on your docket.
F4121-19-9 in the matter of the marriage of Gabriela Flores and Ramon Flores.
Yes, ma'am. I represent Gabriela Flores. This is a divorce case, Judge, that we mediated and settled everything some time ago. I don't know if you remember, this is the one with the pending issue about the wounded veterans house. So it's just set for a status today. But this morning I did talk to John Ball. He's in the hospital with a family member. So I don't know if he was able to appear or not. He wasn't sure if he'd be able to log on. We don't have anything to argue. We're just set for a status.
Okay, how are you feeling? Are you okay?
Me?
Your voice?
Yeah,
So-
I've got, thanks. I have some allergies.
Oh, okay, I suffered with that too. Okay, well, why don't we come back on April the 20th
Yes,
at
ma'am.
9:30?
Sounds good. I'll let Mr. Ball know.
Thank you, Mr. Davis.
Thank
Excuse
you.
me, Your Honor, if I may.
Yes, who's that?
It's Ramon Flores, ma'am.
Oh, that's Mr. Ball's client.
Okay,
I believe you're just waiting for a reply from the organization. I've been trying to get a hold of them myself in regards to your inquiry about trying to find their intent of gifting the home. And I have not been able to get a contact with them. I've been calling them, I've been emailing them. I know last I heard from them that I was going to be one of the last homes that the organization was going to be giving. So I'm not sure if they're still there in operation. But
Okay.
I was going through the documents that we were given, and I know we submitted this for the discovery. It was the residential lease agreement. And on page 4, section 16, it does go over their intent to gift the home to the military member or the service member that is injured as a individual gift and not as a joint gift. Specifically, it mentions it.
Okay, so Mr. Flores, your attorney's not here today, and well, at least I know that I'm not the only one that has been having difficulty in getting in touch with them, because I didn't have any success either. And I had already, I didn't have any different announcement myself, Mr. Davis, from the last time that I was here. However, I think we're going to end up having to staff this case. So let's just let Mr. Ball get back, and then we'll set up an appointment for you, Mr. Davis, and Mr. Ball to come in so that we can staff it.
Yes, ma'am. Sounds good.
Okay. All right, Mr. Flores. Mr. Davis will get in touch with Mr. Ball and we'll staff it in my chambers. And then
Okay.
hopefully we'll find a resolution to it. Okay.
Thank you, ma'am.
All right. Thank
Thank
you.
you, Judge.
Okay. Any other quick announcements before I just start going down? Signify with a raise your hand reaction button.
Judge, if Mr. Juan Ramos, I'm chatting with him right now. I'm not sure if he removed himself. Oh, no, he's right there. He's wearing a maroon shirt.
Okay, Mr. Ramos? Yes, sir. Unmute yourself.
Judge, he's on number 6 on our docket, and these attorneys,
Morning, Judge.
counsel
Good
counsel
morning.
for this case, they both passed this case via Rule 11 and an order resetting. I would hate for him to wait the whole morning if it was passed, Your Honor.
Okay, so Mr. Ramos, I understand that you're here for a divorce. However, the attorneys have, for whatever reason, filed an agreement to pass today's hearing. You may want to get in touch with your attorney to find out why.
Yes, ma'am.
And that way, you don't have to wait anymore.
Perfect. That's good. Let me call them and see what's going on. Thank
Okay,
you, Judge. Have a
all
good
right.
day.
Thank you, likewise.
Bye-bye.
Okay,
Your Honor,
yes,
this is Scott, excuse me, Scott Red.
yes, sir.
I don't know that I was called, sorry.
It's okay.
I'm fighting a bug. I'm on number 35, Ibarra.
Okay, that's CL 201935-I, Leticia Ibarra versus CCRGB Pizza.
Our firm represents Architera, Architera Group.
Okay, and is Mr. Sahad, you're set at 11?
Yes, Your Honor. So
Okay.
I'll just be back at 11 then.
Yes, you can log back in at 11.
Thank you, Judge.
Okay, thank you.
Judge,
Yes, Mr. Brogan?
hi, I'm sorry, I don't have a quick announcement. I actually have 13 debt cases, but I did see that I think 2 of the defendants might be here, so I don't know if it might be wise for me to be able to speak to them before.
Do you want me to put you in a breakout room?
Yes, if possible. The first one that's here is Mr. Number 11 on the docket, Angel Martinez.
Okay, Mr. Martinez, can you hear me?
Yes, ma'am, I can.
Okay, you're gonna see an invitation on your screen to enter into a breakout room so that you can speak to the attorney, okay?
All righty. Thank
So
you,
let
Judge.
me get that for you. Hold on.
Thank you, Judge. And I'm on most of the portfolio recovery cases, Judge, just so you know, if you start getting to those.
Okay, that's good to know. I was wondering who was here for those.
Yes.
Okay,
Yes. I got the invite. Thank you.
okay, go ahead and accept it. All right, Mr. Davis, Attorney Justin Davis.
Good morning, Your Honor. I'm here on number 9 on your docket. It's a friendly suit prove up. I just wanted to advise the court, my client's running just a little bit late this morning.
Okay, just let me know when they're on. I do see that Ms. Thompson is on, so whenever you're ready, we can get started.
Yes, ma'am.
Okay,
Morning, Judge Rogelio Garcia for Hector Torres on that matter.
okay,
Thank you, Judge.
no problem. Okay, Mr. Pruneda, what case are you here on?
Number 25, Your Honor, and I'm just trying to clarify something because I was in the hospital 3 weeks ago with a kidney stones and I've been under medication and there was some discussion between Mr. Thomas Rayfield and I think the other opposing counsel, Ms. Shelley Hopkins. I don't know if it's scheduled for 9:30, 10 or 11. I just need a clarification on that.
At 11.
Okay, very well. Then I'll come back at 11. Thank you, Judge.
Okay, thank you. Okay. Mr. Garcia, Gerardo Garcia, you're here on that friendly suit as well?
Good morning, Your Honor. Yes, Your Honor. Number 8 on your docket. Belinda Ochoa.
Okay, is Mr. Guerra here?
I do.
Good morning, Your Honor. Michael Guerra here for the defendant.
Good morning, Your Honor. Catarina Alvarado as ad litem.
Okay, that's on CL 210179-I, Belinda Ochoa versus Alyssa Elizondo. Okay, and Mr. Garcia, is your client present?
Yes, Your Honor, she is present.
Okay, Ms. Ochoa, can I have you unmute and let me have you raise your right hand?
She's still on mute.
There's a microphone at the bottom of the screen. Just click on that.
Okay, I
All right.
apologize.
That's okay. Raise your right hand, please. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, go ahead, Mr. Garcia. You can start questioning.
Thank you, Your Honor. Good morning, Ms. Ochoa. Can you state your full name for the record?
Yes, Belinda Ochoa.
And can you state your relationship to the children?
I'm their mother.
And what are the names of the children?
Jayla Victoria Ochoa, I'm sorry, and Jaden Jade Ochoa.
And did you bring a lawsuit against the defendant in this case because of an accident that happened on December 13th, 2019?
Yes, that is correct.
And you've reached an agreement with the defendants in this case to resolve any claim you or your children may have against the defendants as a result of this accident?
Yes.
And those claims were related to injuries sustained in the accident, correct?
Yes, that is correct.
And your children received treatment for those injuries, correct?
Yes.
And to be specific, you have agreed to a total settlement amount of $5,000 for Jaden Ochoa, correct?
Yeah, that would be for Jayla, no?
For Jaden.
Jaden, okay, yes. Yes.
And for Jayla, a total amount of $25,000.
Yes, that's correct.
And you understand from each of these amounts, the medical bills, case expenses, and attorney's fees will be paid out of these amounts.
Yes.
And you understand after all those fees are paid, Jaden will take home $1,750.
Yes.
And you understand that after all those fees are paid, Jayla will take home $7,250.
Okay, yes.
And you understand that when I say take home, those amounts will be entered into the registry of the court and not actually taken home.
Yes, I understand that.
And you understand those amounts cannot be withdrawn without a court order or until they reach the age of 18.
Yes, that is correct.
And you understand that should the court approve the settlements, you have agreed to dismiss the case against the defendants on behalf of the children.
Yes.
And you've agreed to dismiss the case against the defendants.
Correct.
And you were also injured in this accident as well, correct?
Hold on. Go ahead.
And you understand that the defendants in this case have tendered the policy limits of the insurance policy to settle this case.
Yes, I understand that.
And do you think that this settlement is in the best interest of the children?
Yes,
And do you request that the court approve this settlement?
I do.
These are all the questions that I have this time, Your Honor. We pass the witness.
Okay, Mr. Guerra, do you have any questions of the witness?
Yes, Your Honor. Thank you. Ma'am, my name is Michael Guetta. I represent the defendant in this action. You understand that you're asking the court to approve the settlement on behalf of Jaden and Jayla, correct?
Yes, I understand that.
And if the court approves this settlement, that you will not be able to come back later and ask for more money on behalf of Jaden or Jayla for this accident. You understand that, correct?
Yes, I understand.
Even if in the future they develop injuries that we don't know about today from this accident.
I understand, yes.
Okay. You understand that you have the right to take their cases in front of a jury.
Yes, I understand that.
And a jury could award less, it could award more, or give you exactly the same as what you're agreeing to settle for today.
Yes, I understand.
And by asking the court to approve the settlement, you understand that you are giving up that right.
Yes.
You understand that the amounts that are going into the registry of the court will be going into the highest interest-bearing account for your children.
Yes, I understand that.
Okay. And are you asking the court to approve the settlement today?
Yes, I am.
Okay. Thank you, Your Honor. That's all I have.
Okay, Ms. Alvarado?
Yes. Ms. Ochoa,
Yes.
you and I spoke about this settlement. Is that correct?
Yes.
And when we first spoke, the amounts were a little different. Is that correct?
Yes, that's correct.
Okay, and since we last spoke, your attorney has agreed to reduce their fees a little so that the children could take home the most amount of money in this case. Is that correct?
Yes, that's correct.
Okay, and you understand that their medical bills will be paid and everything gets paid from the amount of money that they're receiving. Do you understand that?
Yes, yes,
Okay.
ma'am, I do.
Okay, and do you believe this is in your children's best interest?
Yes, ma'am.
Okay, I have no further, and you're asking the court to approve this settlement?
Yes, I am.
Okay, Judge, I have no further questions, and as the ad litem, I believe that this settlement is in the children's best interest and would ask the court to approve it. Mr. Guerra did send over an agreed final judgment. However, the numbers have changed just a little, Your Honor. So just for the record, the monies that will, the way it will be dispersed will be for Jaden Ochoa will be $1,750 into the registry of the court. And for Jayla Ochoa, it will be $7,250 into the registry of the court.
Okay,
And I'll make those changes to the agreed final judgment, Your Honor, and I'll circulate it around to all the parties.
okay. The court is approving the agreement as read into the record. And as soon as that is circulated for signatures and submitted to us, we will sign off on it. Okay, I'm gonna set a tickler for April the 8th, just to make sure that that is submitted.
Thank you, Your Honor. I believe that concludes our business before this honorable court. May my client and myself all be excused.
Yes.
Thank you, Your Honor. Good to see all of you.
Okay.
Your Honor,
Mr. Guerra, do you have something else?
With respect to the ad litem fee, Your Honor, Ms. Alvarado and I were never able to confer on that. So I'll leave that up to the discretion of the court.
That's correct, Your Honor. I did leave a voicemail for Mr. Guerra this morning. However, I've been out of the office quite a bit in the last few months. So I was asking for $1,500 attorney's fees.
Okay, and Mr. Guerra, any objection to that?
No, Your Honor.
Okay, then go ahead and include that in the order.
Absolutely, Your Honor. That concludes my business before this honorable court. May be excused.
You certainly may.
Thank you, Your
May I
Honor.
be excused?
Yes, ma'am.
Thank you.
Thank you. Okay, Mr. Davis?
Your Honor, my client has logged in. She is Maria Maureen. And again, this is on number 9 on your civil docket.
Okay, Ms. Thompson, are you available?
I am, Your Honor. I'm here.
Okay, and Mr. Garcia is on the other side. Okay, let me go ahead and call CL 21-3451-I, Maria Jose Morin Saldierna, SALDIERNA versus Anaili, ANAILI Garcia. Okay,
Justin
and
Davis for the plaintiff's judge.
okay,
Rogelio Garcia for Ms. Garcia, defendant, Your Honor.
And Your Honor, Lucy Thompson here is the ad litem for Ernesto Lopez Jr. and Destiny Salinas.
okay, Ms. Morin, can you please unmute yourself?
Monday, Español.
Oh, okay.
My client will need an interpreter, Judge.
Yes, and she's out at a doctor's appointment. Okay, but I'll do my best. Just go slow, okay?
Okay.
All right. Por favor, ¿puede levantar su mano derecha? Jura que el testimonio que va a dar es la verdad y todo la verdad.
Sí, juro.
Okay. All right. Puede poner su mano. Okay. Go ahead, Mr. Davis.
Can you please state your full name for the record?
Por favor, diga su nombre completo.
María José Morín Saldierna.
Hey, Ms. Maureen, we're here today because of a car accident that occurred on May 27th of 2021. Is that right?
Okay. Ms. Morín, estamos aquí por un accidente de automóvil que pasó el día 20, it was May 22nd?
May 27th.
May 27th, 2021. El día 27 de mayo, el 2021?
Sí, correcto.
Yes, correct.
And your children, Destiny Salinas and Ernesto Lopez Jr. were involved in that accident?
Sus hijos, Destiny Salinas y Ernesto López Jr., ¿también estaban en el accidente?
Sí, correcto.
Yes, correct.
And both Destiny and Ernesto went to the hospital after the accident?
sus hijos Destiny y Ernesto fueron al hospital después del accidente?
Sí, correcto.
Yes, correct.
And they were checked out at the hospital?
¿Y los checaron en el hospital a los niños?
Sí,
Yes.
And that was the only medical treatment that they received for this accident, correct?
Y eso era el único tratamiento médico que recibieron los niños, ¿correcto?
sí, correcto.
Yes, correct.
And as we sit here today, your children are fine. They don't have any lingering injuries, correct?
Que estamos aquí hoy desde este día, sus hijos no tienen problemas tocante físicamente por el accidente.
No,
No.
They're fine, right?
¿Están bien?
sí,
Yes.
And you're here today because we've reached a settlement with the defendant, Annalise Garcia.
Estamos aquí hoy porque usted llegó a un acuerdo con Annalise Garcia.
sí,
Yes.
And you're asking the court to approve the settlement?
Y usted está pidiendo que la corte apruebe el acuerdo.
sí, pues algo así me dijeron que tenía que tener corte.
Yes, something like that. They told me I had to have court.
And you understand that the total settlement amount for Destiny is $5,000?
¿Usted entiende que el para Destiny va a ser $5,000?
Sí,
Yes.
And you understand that out of that $5,000, $383.14 will be reimbursed to Medicaid for the hospital bills that they pay.
De los $5,000, $383.14 se va a pagar a Medicaid por el tratamiento que recibió Destiny en el hospital. ¿Entiende usted eso?
sí,
Yes.
And you understand that out of that $5,000, $1,325 will be paid to the law office of Jay Gonzalez for attorney's fees and case expenses.
Y entiende usted de los $5,000, $1,325 se va a pagar a la oficina de Jay González por los costos de esta demanda.
ok,
Okay,
correcto.
correct?
And the remaining $3,291.86 will be placed into the registry of the court for when Destiny turns 18.
Y el balance de $3,291.86 se va a meter en el con la corte, que es un registry, no sé, pues una cuenta con la corte que va a interés, se va a agregar interés para Destiny cuando ella tenga 18 años.
Ok,
Ok, so usted entiende que eso no se va a tocar hasta que ya Destiny tenga 18 años.
ok, ¿y eso cómo pasará? ¿Ella ir a una parte o no sé?
Okay, how does that happen? Does she go somewhere or how?
Okay, so the money will be placed into an interest-bearing account and it'll earn interest until she turns 18, at which time she can withdraw that money from the county clerk's office.
Okay, el dinero se va a meter en una cuenta que va a agregar interés. Y
Ok.
luego cuando ella tenga 18 años, ella puede ir a la oficina del county clerk para pedir que ella lo quiere sacar porque ya tiene 18 años.
Ok, ya, y me van a dar como una tarjetita, algo para saber dónde es, ¿verdad?
Okay, are you going to give me a card that'll tell me where it is?
I'll absolutely tell you how to withdraw that money for when Destiny turns 18.
Yo absolutamente te voy a decir cómo, te voy a explicar cómo puede Destiny sacar ese dinero cuando tenga 18 años.
Okay.
Okay.
All right, but what I'm asking is, do you understand that that's where that money is going?
Pero lo que estoy preguntando es, ¿usted entiende que es donde se va a ir el dinero? Se va a meter en esa cuenta. ¿Entiende usted?
Pues sí, pues es por su mayoría de edad, me imagino, ¿verdad?
Yes, it's until she reaches 18, I imagine, right?
That's correct.
Yes,
No.
sí, correcto.
You believe that this is in the best interest of Destiny, right?
¿Y usted piensa que esto es en la mejor estado para Destiny?
Pues, pues no, porque falta mucho tiempo, pero pues si es obligación eso, pues está bien.
Well, no, because it's a lot of time, but if that's the obligation. I think she's talking about the money in the interest-bearing account.
I think so as well.
Yeah.
I'm asking Ms. Salinas, do you think that the $5,000 settlement that you're asking the court to approve is in the best settlement of your daughter?
Lo que
Or
le
best
estoy
interest of your daughter?
preguntando es que los $5,000 que le va a tocar a Destiny, que si usted piensa que eso es en el mejor interés de Destiny.
Aunque sí está bien.
Yes, okay.
Now, let's talk about Ernesto.
Okay, vamos a hablar de Ernesto.
You understand that the total settlement amount for Ernesto is $5,000 as well?
¿Entiende usted que el total para Ernesto también va a ser $5,000?
Sí.
Yes.
You understand that out of that $5,000, $408,000.85 will be paid to Medicaid for the hospital bills that they paid on his behalf?
¿Y usted entiende de esos $5,408.85 se va a pagar a Medicaid por el tratamiento que Ernesto recibió en el hospital?
Okay.
Okay.
You understand that?
¿Entiende usted eso?
Sí.
Yes.
You understand that out of the $5,000 settlement, $1,325 will be paid to the law office of Jay Gonzalez for attorney's fees and case expenses?
¿Usted entiende que de esos $5,000, $1,325 se va a pagar a la oficina de Jay González para los costos de esta demanda?
Sí, correcto.
Yes, correct.
And you understand that the remaining $3,266.15 will be paid into the registry of the court and deposited into an interest-bearing account for Ernesto for when he turns 18?
¿Usted entiende que el balance de $3,266.15 se va a también meter en una cuenta que agrega interés para Ernesto hasta que él también llegue a 18 años?
Sí, correcto.
Yes, correct.
And you believe that this settlement is in the best interest of Ernesto, correct?
¿Y usted piensa que esto es en el mejor interés de Ernesto?
Sí, correcto.
Yes, correct.
You understand that you had a right to a jury trial in this case?
¿Usted entiende que usted tenía el derecho de un juicio en este caso?
Sí.
Yes.
You understand that if this case had gone to a jury trial, a jury may have awarded more money, less money, or no money than what you're asking the court to approve today?
¿Usted entiende que si usted fuera llevado este caso a un juicio, que unos jurados a lo mejor le fueran dado el mismo cantidad, más de esta cantidad o menos de esta cantidad que usted está preguntando que la corte apruebe? ¿Usted entiende eso?
Sí.
Yes.
And you're giving up that right freely and voluntarily to enter into this settlement today, correct?
Y usted está negando ese derecho voluntariamente para entrar en este acuerdo hoy?
Sí.
Yes.
And you understand that if the court approves this settlement, In the future, there will be no other recourse that will be available to your children against Annalie Garcia, the defendant. Do you understand that?
Y usted entiende que si la corte aprueba este acuerdo, entonces ya no tienen el derecho los niños para demandar o hacer algo a contra de Annalie Garcia. Aquí se termina.
Sí, está bien, correcto.
Yes, okay, it's fine. Correct.
In other words, this is all the money they'll ever receive from this car accident. You understand that?
En otras palabras, este va a ser todo el dinero que van a recibir los niños.
Okay.
Okay.
You understand that?
¿Entiende eso?
Sí, correcto.
Yes, correct.
And you're asking the court to approve the settlement because you believe it's in their best interests, right?
Y está usted preguntando o pidiendo que la corte apruebe este acuerdo porque es en el mejor interés de los niños, ¿correcto?
Correcto.
Correct.
And you've been satisfied with the services that you've received from the law office of Jay Gonzalez?
Y usted está satisfecho que los servicios que le ha dado Jay González a usted en este caso?
Sí, correcto.
Yes, correct.
Your Honor, I'll pass witness.
Oh, I think I've already used up all my Spanish for the day. Okay.
I tried to go as slow as possible, Judge.
Okay, go ahead, Mr. Garcia. Ahora va a tener preguntas el abogado licenciado Garcia, okay?
Your Honor, you did a great job, admirable job, and Mr. Davis did such a thorough job. I don't have any questions, Your Honor.
Okay. Dice él que todas las preguntas que el licenciado Davis le hizo, pues eran más de suficientes, o él no tiene preguntas para usted. Okay. Ms. Thompson, do you have any questions?
Just a couple, Your Honor.
Okay. La licenciada Thompson tiene nomás unas preguntas, unas cuantas preguntas para usted.
Señora Morin, I'm sorry, Mrs. Morin, we met last month, is that correct?
Señora Morin, nosotros nos juntamos el mes pasado.
Sí.
Yes.
And we discussed the injuries that Ernesto and Destiny had.
Y discutimos como las lástimas que tenían los niños Destiny y Ernesto.
Sí.
Yes.
And you indicated that today they are no longer suffering from any injuries. Is that correct?
Y usted platicando con ella indicó que ya no tienen, ya no están lastimados.
Sí, correcto.
Yes, correct.
Okay. Judge, those were all the questions I had because Mr. Davis again did such a good job of it. But I would like to say for the record that I did meet with Mrs. Morin and discuss the injuries to Ernesto, who is 2 years old, a year and a half, and to Destiny, who's 10 years old. And Mrs. Morin did indicate that, you know, the injuries are no longer existing and that she was satisfied with the settlement. I'm sorry, I went a little fast because that needs to get translated. I apologize.
No, it's fine. I'll just do a general.
Got it.
Okay, señora Morin dice que ella nomás quería clarificar para la corte que sí se juntó con usted y platicaron tocante de lo que le pasó a los niños y que usted sí le dijo a ella que indicó que usted estaba muy bien con lo que estaban recibiendo los niños en este caso y que ya no están lastimados.
Sí, correcto.
Yes, correct. Okay.
Your Honor, if I may, Your Honor, I'm sorry. I just want to, on the record, and inform the court that this policy was exhausted. There were several claimants, and the two children received what was left, and it was a minimal policy that was tendered in this particular matter.
Okay. All right. And Ms. Thompson, have you already discussed your fees with defense counsel?
I have, Your Honor, and it's already been paid. Thank you so much.
Okay, so then, just, has the order already been circulated then?
Yes, ma'am. Your Honor, the order was circulated yesterday, returned yesterday, and we were just waiting for the court, this honorable court to approve settlement, and it'll be filed, if not this afternoon, by tomorrow.
Okay, then the court will take judicial notice of all the documents in the court's file, approve the settlement as read into the record, and will sign off on the order as soon as it comes through my queue. So, señora Morín, ya se concluyó todo, terminó aquí hoy. So, yo voy a firmar la orden ya cuando llegue en mi oficina, ¿ok?
Okay.
Ok, y le pido disculpa que no lo traducí lo mejor que podía porque la que...
Okay, muy bueno.
Okay, so, but anyway, this is when I regret not being more fluent in Spanish, but oh well.
You did a great job, Judge.
Thanks. Well, at least in the good old days, it wouldn't be on YouTube for everybody to see. For a while. But anyway, okay, señora Murindo, le deseo lo mejor, que Dios la bendiga.
Igualmente. Pues.
Okay, so Mr. Davis, just get in touch with her and explain to her how they can get that money.
Absolutely, Your Honor. And that
Okay.
concludes my business before this honorable court. May I please be excused?
Yes, you may.
Same, Your Honor. May I be excused?
Yes, you may.
Thank you, Judge.
Thank you. Okay, ya se puede retirar, Ms. Morin. All right, back to English. Ms. Van Schuver, please help me with your last name. I always have trouble.
Good morning, Your Honor. Amber Van Skyver.
Van Skyver. There we go. Okay, and who's on the other side?
Your Honor, I'm here with Ms. Tony Ramirez. We have an agreement.
Oh, great. Okay, that's number 31 on the court's docket.
Yes, Your Honor.
F2114-20-9, Juan Armando Campos versus Maria del Pilar Campos.
Yes, Your Honor, and I do apologize in advance. My client is a Spanish speaker.
It's okay. There's no need to apologize. Usually, you know, we have our translator, but unfortunately, she's got some medical issues right now, so she's at the doctor. Okay, so is Ms. Ramirez present? Ms. Ramirez, can you hear me? I'm not sure, Ms. Ramirez, you know you're on mute.
Okay, am I open now? All right.
Yes, I can hear you now. All right, and so do we have Juan Campos and Maria Campos?
Mr. Campos is here with me.
Okay.
And Ms. Campos is on the screen, Your Honor.
Which one is she?
Maria del Pilar Campos.
Okay, there you are. Okay, there she is. All right, and who are we proving it up with?
I can prove it up, Your Honor.
Okay, just go slow.
Yes.
Are there children in this?
No, Your Honor.
Okay.
Children are all adults.
All right, hopefully it'll be nice and smooth then, if it's just property. Okay, señora del Pilar Campos, por favor, ¿puede levantar su mano derecha?
Your Honor,
Yes.
the petitioner is Mr. Campos.
Okay, well, did you want to prove it up instead?
Yes.
Okay, all right. And then can you turn your screen on so I can see your client?
¿Sí me escucha, Miss?
Okay, sí le escucho.
Okay. Okay, gracias.
Okay, por favor levanten la mano derecha. Señor Campos, okay, ¿juran que el testimonio que van a dar es la verdad y nada más que la verdad? Ms. Campos, ¿sí o no?
Lo juro.
Sí.
Okay, I
Sí.
swear. Mr. Campos says, I swear, and Ms. Campos says, yes. Okay, pueden bajar su mano. Okay, Ms. Ramirez, just go slow, please. Go ahead.
Your name is Juan Armando Campos.
¿Su nombre es Juan Armando Campos?
Yes.
Okay, do you want to do it in English, Mr. Campos, or in Spanish?
English.
Okay, go ahead.
Is respondent Maria del Pilar Campos.
Yes.
Have you been a domiciliary of the state of Texas and a resident of Hidalgo County for more
Yes.
than 6 months before filing?
Yes.
Your Honor, were you going to translate?
Well, I mean, I'm gonna translate for her when when her attorney will ask her the questions with respect to,
All right.
to the agreement.
Okay. Has your marriage become insupportable because of conflicts?
Yes.
Is there a possible reconciliation?
No.
There's no children under the age of 18?
No.
No children expected?
No.
Have you made an agreement with Mrs. Campos to divide the property?
Yes.
You will keep the personal property and your 1998 Chevrolet pickup.
Yes.
Mrs. Campos will keep the 50% of the property at 6804 Olivares Street in Pharr, Texas.
Yes.
And you had already conveyed your 50% to your 2 adult children.
Yes.
Now, Mrs. Campos will keep the personal property there at her residence where she lives.
Yes.
And you plan to make a police report for a stolen trailer. Is that correct?
Yes.
And Mrs. Campos will keep the 2003 Ford Expedition.
Yes.
Now, do you own a 2008 Mercury motor vehicle?
No.
Now, Mrs. Campos also has a 2011 Ford Focus.
Yes.
And she will also transfer title to the 2007 Avalanche truck to her son, Carlos Campion.
Yes.
And the 2010 Sierra pickup to Karen Campos.
Yes.
And you will, on the debts, you will pay the debts that you have incurred, and also $3,000 in a payment plan for a year for some property taxes for 2018 to 2020.
Yes.
Now, Mrs. Campos will pay the rest of those taxes.
Yes.
Now, you've also agreed to pay Mrs. Campos maintenance payments.
Yes.
And those are based on the circumstances of the parties and the division of the property.
Yes.
And those payments will be $300 per month, starting April the 1st, 2022, at an address to be provided by Mrs. Campos. And they will continue for 72 months until March 2nd, 2028. Is that correct?
Yes.
Now, also, there are other conditions that they will change. If either party dies, there are no more payments.
Yes.
If Mrs. Campos remarries, the payments also stop,
Yes.
or until other orders are made by a court.
Yes.
Okay. Now, do you also agree that if you do get an employer, that your employer can withhold these payments and forward them to Mrs. Campos?
Yes.
And you agree that there will be an injunction, permanent injunction, mutual permanent injunction where neither of you can communicate with each other by mail, by telephone, in any way, except as to provide an address
Yes.
of your employment or where to send the payments to Mrs. Campos.
Yes.
Also, you will not get within 500 yards of each other,
Yes.
and you will not inflict any personal injury or contact with each other.
Yes.
Now, Mrs. Campos is requesting a name change to Espinosa. Her name will be Maria del Pilar Espinosa.
Yes.
All right. Are you asking this court to grant you a divorce?
Yes.
I will pass this witness to Ms. Van Schreiber.
Okay, Ms. Van Schreiber, do you have any questions of Mr. Campos?
Just a couple, Your Honor.
Okay, go ahead.
Mr. Campos, you and Mrs. Campos were married on or about April 25th of 1994, is that correct?
Yes. Translation,
1994.
1994.
Okay, why would we translate for him if he just testified everything in English? So, Mr. Campos, was your date of marriage April 25th, 1994? Yes or no?
Matrimonio.
Yes.
Okay, go ahead.
And Mr. Campos, you understand because you already signed a deed giving your portion of the residence and FAR to the children. The remaining portion will be awarded to Mrs. Campos.
La casa.
Yes.
And you are in agreement regarding the $3,000 for the property taxes that you will enter into a monthly payment plan with the Hidalgo County Tax District and pay those on or before March 23rd of 2023.
Yes.
And you're asking the court to approve the agreed division of the property?
Yes.
Acepte la corte.
Yes.
Your Honor, I have no further questions for Mr. Campos.
Okay, and of your client?
Yes, Your Honor.
Okay, go ahead. Just go slow. Go ahead.
Mrs. Campos?
Señora Campos?
Sí, dígame.
Yes, tell me.
You and Mr. Campos have 3 children together who are all adults, correct?
Usted, el señor Campos, tienen 3 hijos juntos, pero ya son mayor de edad. ¿Correcto?
Sí, correcto.
Yes, correct.
And you're not currently expecting any children, nor did you adopt any children.
Y usted ahorita no está embarazada y no adoptaron hijos, ¿correcto?
Sí, correcto.
Correct.
And you and Mr. Campos have reached an agreement regarding division of the property?
¿Y ustedes han llegado a un acuerdo tocante de dividiendo los bienes?
Sí, correcto.
Correct.
And you're asking the court to approve that agreement?
¿Y usted está pidiendo que la corte lo apruebe?
Sí, correcto.
Yes, correct.
You're asking that the court award you the remaining interest in the residence and FAR?
Usted está pidiendo que la corte le dé a usted lo resto del interés de la casa en FAR?
Sí.
Yes.
And during the marriage, your son purchased a 2011 Ford Focus and gifted it to you, correct?
Durante el matrimonio, su hijo compró un Ford Focus 2011 y se lo regaló a usted?
Sí, correcto.
Yes, correct.
And you're asking the court confirm that as your sole and separate property.
Y usted está pidiendo que la corte confirme eso como su propiedad separado.
Sí, correcto.
Yes, correct.
And you're requesting that Mr. Campos be awarded the 1998 Chevrolet truck and all
Usted,
debt associated with that vehicle.
usted está pidiendo que el señor Campos se le dé el 1998 Chevrolet, la troca Chevrolet y cualquier deuda que está asociado con ese camioneta.
Sí, correcto.
Yes, correct.
And you are asking that you be awarded the 2003 Ford Expedition
Y usted está pidiendo que la corte le dé a usted el Ford Expedition 2003.
Sí, correcto.
Yes, correct.
and you understand you will be responsible for the lien on that vehicle.
Y usted está, usted entiende que va a ser responsable de las deudas de ese camioneta?
Sí, correcto.
Yes, correct.
And regarding the FAR residence, you owe several years of back taxes, is that correct?
Y tocante de la residencia en FAR se debe años de taxas de propiedad que están atrasados.
Sí, correcto.
Yes, correct.
And you have agreed that Mr. Campos will pay $3,000.
Y usted, I'm sorry, go ahead.
Mr. Campos will pay $3,000 of the past due taxes by March 23rd, 2023.
Ok, ¿están de acuerdo que el señor Campos pague $3,000 de los taxas que están atrasados para la fecha 23 de marzo 2023?
Sí, correcto.
Yes, correct.
And you understand you will be responsible for the remaining balance.
¿Y usted entiende que va a ser responsable del balance?
Sí, es correcto.
Yes, correct.
And you've agreed that you each will keep whatever personal property, cash, or money in bank accounts that is in each of your possession.
¿Y ustedes están de acuerdo que se van a quedar cada uno con su propiedad personal, cuentas del banco que está en la posición de cada uno y en su solo nombre?
Sí, es correcto.
Yes, correct.
Your son, Carlos Campion, purchased a 2007 Chevrolet Avalanche that is currently titled in your name, correct?
Su hijo Carlos Campión compró un 2007 Chevrolet Avalanche que está en el nombre de usted.
Es correcto.
That is correct.
Did you pay for the vehicle?
¿Pagó usted para esa camioneta?
No.
No.
And you do not currently have the car in your possession?
Y usted no tiene esa camioneta en su posesión.
Ahorita no.
Right now, no.
And you are in agreement that the title should be transferred to your son, Mr. Campion, since he is the rightful owner?
Y usted está de acuerdo que el título de esa camioneta se transfiere a su nombre de su hijo Carlos Campión porque él es el dueño.
Correcto.
Correct.
Your daughter, Edna Karen Campos, purchased a 2010 GMC Sierra that is titled jointly in your name, correct?
Ok, su hija Edna Karen Campos compró una GMC Sierra 2010 que el título está en el nombre de los dos, usted y su hija, ¿correcto?
Correcto.
Correct.
And your daughter is the one that purchased that vehicle?
Y su hija es la que compró esa camioneta.
Sí, es correcto.
Yes, correct.
And you're in agreement for the title to be transferred fully into your daughter's name?
¿Y está de acuerdo usted que ese título se transfiere al nombre de su hija?
Es correcto.
That is correct.
And you're asking to approve this division of the property?
Y usted está pidiendo que la corte apruebe esta división de la propiedad?
Sí,
Yes.
You and Mr. Campos were married for over 20 years.
¿Usted y el señor Campos estaban casados más de 20 años?
sí,
Sí. Yes.
And you are not working and unable to support yourself at this time, correct?
Y usted no está trabajando y no se puede mantener sola, ¿correcto?
correcto.
Correct.
And you and Mr. Campos have agreed that he will make monthly payments of spousal maintenance in the amount of $300 beginning April 1st of this year.
Usted y el señor Campos ha llegado de un acuerdo que él le va a pagar mantenimiento en la cantidad de $300 por mes que va a comenzar el día 1 de abril de este año.
Correcto.
Correct.
And those payments are to continue for 6 years unless either one of you pass away or you remarry.
Y esos pagos van a continuar por 6 años, solamente si no fallecen, vayan a fallecer o que usted se vaya a volver a casar.
Correcto.
Correct.
And you're also asking the court to approve the permanent injunction that will be included in the divorce decree, that you and Mr. Campos are to have no contact with each other than to inform each other of any changes to your mailing address or for Mr. Campos's employer.
Y usted está pidiendo que la corte apruebe las restricciones, que el señor Campos no, que no tengan contacto con cada uno, usted como él y él como usted. Y nomás solamente para avisarle si se le cambia el dirección del correo o si él se cambia de empleados.
Correcto.
Correct.
And you're asking the court to change your name to Maria del Pilar Espinosa.
Y usted está pidiendo que la corte le cambie el nombre, el apellido a María del Pilar Espinosa.
Correcto.
And Miss Van Sciver, can you please spell if it's Espinosa with an S or a Z?
With a Z.
So it's Espinoza?
Yes.
Okay. Okay, go ahead.
And Mrs. Campos, you've entered this agreement freely and voluntarily?
¿Usted entró en este acuerdo voluntariamente?
Sí, es correcto.
Yes, that is correct.
And you're asking the court to approve the agreement and grant the divorce today?
Y usted está pidiendo que la corte apruebe este acuerdo y le dé el divorcio hoy?
Sí, correcto.
Yes, correct.
I pass the witness.
Okay, Ms. Ramirez, do you have any questions of the witness?
I have just one or two, Your Honor.
Go ahead.
Mrs. Espinosa or Mrs. Campos. Is there a trailer that Mr. Campos left there on the property that he had borrowed from another person?
Señora Campos, el señor Campos dejó una traila en esa propiedad que él se lo prestó a otra persona.
Tocante esa traila, el único que tiene que hablar él es con Jorge Campos y él fueron los que vendieron esa traila. No sé, eso apenas que hable con Jorge Campos. Él es el encargado de eso. Yo no sé de eso.
In regards to that trailer, he needs to speak to Jorge Campos. He is the one that was in charge of that trailer and the sale of that trailer. That she doesn't know. I do not know anything about it. He needs to speak to Jorge Campos.
All right. Mrs. Campos, do you want for Mr. Campos to mail you the first check of $300, which will be in about a week, to 6804 Olivares Street in Far, Texas?
¿Usted quiere que el señor Campos le mande el primer pago de mantenimiento a la dirección 6804 Olivares Street en FAR?
Sí, es correcto.
Yes, that is correct.
Okay, that's all I have, Your Honor.
Okay, ya no tiene ella ninguna preguntas. Okay, the court is going to take judicial notice of all the documents in the court's file and agree and approve the agreement as read into the record and testified to by the parties. It'll be set forth in further detail in a divorce decree that is to be signed by all the attorneys and the parties. And how much time do y'all need to submit that?
A week should be sufficient, Your Honor. We already have it ready. We just need to make a couple of changes.
Okay, I'm gonna set a tickler for April the 8th.
Yes, Your Honor. May we be excused?
Yes, if nothing further, you all are excused.
Thank you so much.
Thank you, Judge.
Thank you. Y'all have a good day. Señora
Thank you.
Campos, ya
Sí.
se puede retirar.
Gracias.
Thank you. Okay, Mr. Ramos, what do you have?
Good morning, Your Honor. I have two matters. The first one's number 3 on your docket.
Okay, F3311-21-9 in the matter of the marriage of Manuel Cázares, CASAREZ versus Ursula, ERCILIAR Cook.
Yes, and Mr. Cáceres is currently on Zoom on Manuel's S10 Plus, I believe.
Okay, and do you need to prove up a divorce?
Yes, Your Honor, we have a divorce decree signed by all parties. The respondent's attorney of record advised me that they wouldn't be able to attend, but we're ready to prove up through Mr. Cáceres.
Okay, who represents Ms. Cook?
Ms. Cook is represented by Mr. Joel or Jason Hirschler, I believe.
Okay. All right, hold on, give me a moment. Okay, Mr. Cáceres, please raise your right hand.
I got it.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may proceed.
All right, thank you. Mr. Cáceres, can you please state your full name for the record one more time?
Manuel Cáceres.
And Mr. Cáceres, is it true that you and Miss Ursula Cook have entered an agreement to finalize your divorce today?
Yes.
And you're ready
Okay,
to...
hold on, Mr. Ramos. I'm getting a lot of feedback. I'm not sure if that's coming from Mr. Cáceres's area.
There's no feedback here.
Okay, go ahead.
All right. Mr. Cáceres, prior to filing this divorce petition, did you live in the state of Texas for the last 6 months in Hidalgo County, 90 days?
Yes.
And as far as any children under the age of 18, you, Ms. Cook, do not have any children under the age of 18, and nor are you expecting any children at this time. Is that true?
That's true.
Okay. And as far as the divorce agreement, you and Ms. Cook have agreed to the division of your property. Is that true?
Yes.
And as far as that agreement, you have agreed to retain a property in Far, Texas, and Ms. Cook is going to retain her property in Enberg, Texas. Is that true?
That's true.
And each of you are going to retain the debts that are in your respective names and bank accounts in your respective names and personal property in your respective possession?
Judge,
yes.
I need that question repeated.
Okay, yeah, there's some, I don't know if it's his, you're gonna need to repeat some of that.
Okay.
Hold on, I don't have anybody, it's gotta be coming from one of your areas. So, okay, where did you need them to?
The last question he said pertaining to the debt.
Hold on, let me see. Yeah, it's coming from Mr. Cáceres' phone.
Judge, are they in the same room by chance? Sometimes it picks up or like nearby.
No,
he's at work.
Oh, okay.
I don't know, Mr. Ramos, it's not. What I'm gonna do, since I don't have any minor children and they've already signed off on the decree by everyone, I'm gonna allow it to be by submission, okay?
We appreciate it, Judge.
Yeah, because I don't know, that way he doesn't have to continue walking all over the place.
Understood, Your Honor.
Okay,
We
just go ahead. Mr. Casares, I'm not sure why we're getting some feedback from you, but since you and your wife have already signed off on the decree and there aren't any minor children, I'm gonna go ahead and accept it, and I'll do the divorce by submission, okay? So you're excused, sir. Okay, just
Thank
get
you,
that
Ms.
in,
Castro.
Mr. Ramos, by April the 8th.
Will do, Judge.
Okay, thank you.
And then I have one other matter, Your Honor.
Yes, sir.
It's number 30 on your docket, Judge.
F2111-20-9 in the matter of the marriage of Rodrigo Reyes and Kenya Lopez Reyes.
Yes, Your Honor, for the record, Juan Ramos here on behalf of Mr. Rodrigo Reyes, the petitioner.
Okay. And Kenya Reyes, is she present?
I don't see her present, Your Honor.
Okay, and what is the announcement in this matter, Counselor?
Well, Judge, we were trying to finalize this divorce. I know that the state had filed a separate SAPSR, and at our last master court hearing, they were going to dismiss that SAPSR and file an intervention in this divorce. But I have proactively gotten Mr. Reyes's income information to try to calculate the retro and the child support. But without Ms. Reyes being here, I think we're not going to be able to finalize the divorce today because there's minor children, of course, Judge.
Okay, Ms. Trevino, I don't mean to put you on the spot, but do you know if you all are filing an intervention on this case? Can I give you a case number or?
Yes, Judge. It just from what Mr. Ramos said, that's an establishment case, but I can look at it. If I get the cost number, I can search for it.
Okay, F-2111-20-9.
Okay, if I may just have a few minutes, Judge.
Yes, because Mr. Ramos, what can happen is if for some reason the AG isn't going to file an intervention after all, if she has proper notice of the next hearing, which she should, because I'm going to ask you to file an order setting hearing and send it to her last known address. If she doesn't show up, we're just going to proceed without her. So, but if the AG, we'll just wait to see what they do, because he can't be expected to stay married this whole time.
No, Your Honor. And actually, she has attended in the past every hearing. So I'm surprised she didn't attend today. But we'll make sure to get that done as soon as possible.
Okay, so while Ms. Trevino's checking that for me, I'm gonna go ahead and just, I'll recall the case shortly.
Yes, Your Honor.
Mr. Brogan, what's your announcement?
Hi, Judge. I have 2 cases out of 13 I have on the docket that
Okay,
I
go
met
ahead.
with. I met with the defendant and we settled. The first one is number 11 on the docket.
All right, CL 170795-I, Portfolio Recovery versus Angel Martinez. And Mr. Martinez is present. And what is your announcement, Counselor?
Judge, we settled. I sent Mr. Martinez the agreed judgment by email already, so we're going to be waiting on that, and then we'll just file the agreed judgment. If we can have a 60-day reset on either this docket or a settlement docket, we should be able to get it.
Okay, what I'll do is I'll just set a tickler, which is just a court reminder for May the 27th, just to make sure that the settlement documents or the appropriate documents have been filed.
Okay, thank you, Judge.
Okay, so Mr. Martinez, just make sure to comply with the agreement that you've entered into.
Yes, ma'am. Yes, Your Honor.
Okay. All right, sir, then you are excused.
Thank you.
Okay,
Have a
your
good
next
day, Your Honor.
case. You too. Your next case?
Judge, my other case that's settled is Miss Yvonne Dominguez. This is number 20 on the docket.
CO 184561-I Portfolio Recovery Associates versus Yvonne Dominguez. And that's IVONNE. Okay, go ahead, Mr. Bergen.
We also settled that, Judge. Same announcement. I'm going to email her the agreed judgment so we can have that ticker date.
Okay, I'm gonna set a tickler for the court for May 27th, and that'll just be for me. You all don't appear or anything. We're just gonna look to see that it's been filed.
Okay.
Okay, Ms. Dominguez, just comply with the agreement, okay?
Okay, thank you, Jim.
All right, thank you. Well, Mr. Bergren, maybe I should have you do all my mediations then. You settle in 2 minutes.
I've done so many in the past, but I have 11 cases left, Judge. So if the other attorneys want to handle their cases first, I'll just be doing defaults.
All right. Okay, we'll get it.
Thank you.
Okay, Ms. Trevino, were you able to find out anything?
No, Judge, I sent a message to Mr. Ramos if he can give me the SAPSR cost number because I'm not getting results with the divorce cost number.
Okay, I'll go ahead and let you do that. All right, Mr. Kennedy, Attorney Patrick Kennedy.
Judge, I don't know Mr. Brogan, but I thank him for that consideration. That's very nice.
You're welcome.
Judge, I've got a default divorce hearing today, and I think it's number. Let me find it on here. I think it's either 1, 2, or 3. Let me see.
Number 1. It's F1704-21-9 in the matter of the marriage of Juana Salinas and Jose Salinas.
Yes, Your Honor. I believe my client is present. I'm not sure about Mr. Salinas.
Okay, Juana Salinas, are you present? Juana Salinas, are you present? Okay, I think she just click the microphone at the bottom.
Hello?
Okay. And Jose Salinas, correct? Let me just.
Okay, what happened?
I can hear you. You're fine. Can you hear us? Miss Salinas, can you hear us?
Yes, I can hear you now.
Okay, perfect. Let me see. All right, please, let me call out the name, Jose Salinas. Jose Salinas, Jose Luis Salinas. All right. His name being called out 3 times, no response. I do see that the order setting hearing was sent to Mr. Salinas's last known address in McAllen, Texas. Ms. Salinas, let me have you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. You may lower your hand. You may proceed, Mr. Kennedy.
Okay, thank you very much. Ms. Salinas, have you been living in Texas for the last 6 months?
Yes.
And have you been a resident of Hidalgo County for the last 90 days?
Yes.
Okay. And you were married on or about November the 12th, 2004. Is that correct?
Yes.
Okay. And you separated more or less on April the 8th, 2021?
Yes. Well, he hasn't moved yet. He's going to be moving as soon as he signed the petition. That's what he said.
Okay. But you stopped living together as man and wife on that date?
Yes.
Okay. Now, you've come to the court today because you're asking for a divorce. Is that right?
Correct.
And would you say your marriage has become insupportable because of conflict of personalities?
Correct.
And there's no hope of reconciliation. Is that right?
Right.
Okay. Now, I'd like to talk about your children and some proposed orders for your children now, okay?
Mm-hmm.
You currently have 4 children. Is that right?
Yes.
Anahi?
Anahi?
Crystal?
Don't, Mr. Kennedy, just because we're on YouTube, don't put the kids' names on the record.
Okay, not a problem, Your Honor.
It's sufficient just that it's 4 children.
Yes, Judge. So
Okay.
you have 4 children, and you're not currently pregnant. Is that correct?
And I'm currently what?
You're not currently pregnant. Is that correct?
No.
Okay. And today you're asking that you and your husband, or soon to be ex-husband, will be appointed joint managing conservatorship. Is that right?
Correct.
With
Yes.
with you being the primary conservator.
Yes.
Okay, and you're asking that a standard visitation be ordered.
Yes.
Okay, and you're also asking that no parties engage in drugs or alcohol while visiting with the children. Is that correct?
Correct.
Okay. Now let's talk about your property. Now, you don't own a home, is that correct?
Correct.
Oh, I'm sorry, going back to the children, you're going to provide medical support for your children, is that right?
Yes.
And at this time, you're asking the court to not make any orders regarding child support.
Correct.
Okay. Now, moving forward to your property, you're asking that you keep whatever personal items you have in your possession and that Mr. Salinas keep whatever personal items he has in his possession. Is that correct?
Yes.
Okay. And you're asking the court to award you the Kia car that you all purchased during your marriage. Is that right?
Yes.
Okay. And along with that car, though, you're going to be taking on the car's debt that's currently held by Sanders Consumers USA.
Yes.
Okay. You're also asking the court to award you your bank account held at Texas Regional Bank. Is that right?
Yes.
Okay. Now, does Mr. Salinas have a bank account that you're aware of?
No.
Okay. And finally, you're asking that the court change your name from Juana Salinas to Juana Abundis.
Yes.
And that Abundis is your maiden name. Is that correct?
Yes.
Okay. No further questions, Your Honor.
Okay. So the court will take judicial notice of all the documents in the court's file, specifically the service. Let me see. Mr. Kennedy, I'm not sure if you're aware, but your return of service is not on file.
I show that it was filed on August 23rd, Your Honor.
Unless I'm looking at the wrong, are you sure?
What I've got here is that the return was filed on August 23rd, 2020.
Oh, 21. Hold on. Yes, they have it. It's because the clerk had titled it differently.
Oh, okay. I apologize for that.
Okay, no, it's not your fault. Okay, so the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. And the court is granting the relief as requested by the petitioner in this matter and set forth in a divorce decree that'll be submitted by what date, Mr. Kennedy?
I think we can have it together in 2 weeks, Your Honor.
Okay, I'm gonna go ahead and set that tickler for April the 8th. Since we already have a lot of other stuff due that day, we'll be checking anyway.
Okay. I could probably have it to you sooner. I'm just giving us some extra time as a buffer.
That's fine. Okay. All right. Make sure that your client signs off on it though.
Yes, Your Honor. We will.
Okay. Anything else?
No, Your Honor. Nothing from me today, Your Judge.
Okay. Then you are excused. Best of luck to you, ma'am.
Thank you.
Okay. Ms. Trevino, any luck?
No, Judge, I'm waiting for Mr. Ramos to respond to my chat request.
Oh, Mr. Ramos, he might be in another court. I saw he was doing double screens.
Oh, okay.
All right. Okay. We'll take him up. Well, when he gets back, we'll ask him.
Okay.
All right, Mr. Vasquez?
Yes, Your Honor. I'm sorry. Judge,
Go ahead.
I'm sorry.
Go ahead, Mr. Vasquez.
Okay.
I'm ready for the agreement.
Thank you, Judge Hinojosa. Okay. I'm sorry, Judge. I'm here.
Okay. So are you F3326-04-9 in the interest of minor children?
Correct, Your Honor. I'm here on behalf of Miss Irene Jeanette Rodriguez, Your Honor.
Your Honor, Edna Cedillo, on behalf of Mr. Rodriguez, I believe I was appointed at a previous hearing, Judge, to represent his interests, Your Honor.
Isabel Trevino for intervener office, the state of Texas.
Yes, because at the I think for this matter, Mr. Rodriguez was facing possible jail time.
That's correct, Judge.
Okay. And Is Mr. Rodriguez present?
He should be on.
Hold on. I'm not sure, Mr. Vasquez. I think I'm getting some
Other
feedback.
back. Yes, Your Honor. I think I put it in mute. Yes. Let me put it lower. Okay, Your Honor. I apologize.
Okay, so Mr. Rodriguez doesn't look to be present. He's been present in all the other hearings.
Yes, Judge, and I spoke to him as late as yesterday. He should be on, Your Honor.
I'm here.
I'm sorry?
Oh,
I'm
there
here.
he is. Okay. All right. So I see that Ms. Rodriguez is also on. So the parties are on. And what is the announcement?
Your Honor, on behalf of Mr. Rodriguez, Your Honor, I'm going to be asking for some additional time. I had an opportunity to speak to him. My understanding that there is now a wage withholding order that is taking effect, and there's some money coming in. In addition to that, there was a intercept that was garnished from him, Judge, which has also been applied to his overall balance. And he's telling me that possibly with some additional time, Your Honor, he could come up with a small lump sum, Judge, in the amount of $500 to help that balance. I believe the total balance, including the medical, is about $8,000 at this point. If the court would entertain a month or so, Judge, maybe 2 months, he's indicating that he can probably come up with $500, but in addition to the wage withholding that's already in effect, Judge.
Okay, Mr. Vasquez?
Yes, Your Honor. That is true, Your Honor. Although money has been withheld and then paid to the Attorney General, that money has been it goes directly to the medical bills, past medical bills that he has, Your Honor. So we have not received any money. I think we've received about a couple, I guess, a little bit of money, my client told me. But we would like to see if he can pay at least $500 by the next hearing, and at least the service fees that we had to get him served with to get him present at the last hearing, Your Honor, in February. So that's the agreement we're working on right now, Your Honor. So we're in agreement to a little bit more time.
Judge, and just for the record, there have been some administrative collections. We did have a collection post yesterday.
Yes.
Okay.
That's the intercept that I was referring to, unfortunately, because it was garnished. My understanding that entire amount goes to any money due to the state. So Mr. Vasquez is correct in indicating that he did not receive that. At least that was my understanding in speaking to the Attorney General's office yesterday. So the state will collect generally their funds first. But Your Honor, if it's money that's taken from him directly, that would go directly to her. So we'd ask the court for an opportunity to give some sort of lump sum.
And with this latest intercept, there is some part of it going, will be distributed to Ms. Rodriguez.
Okay. So what I'm going to do is I'm going to go ahead and give Mr. Rodriguez that time, and I'm going to have y'all come back on May the 25th and see how much he can get paid down by that date.
Yes, Your Honor.
And that'll be at 9:30.
That was May 26th, Your Honor?
25th.
25th.
Thank you, Your Honor. I'll discuss that with my client so we can make some progress on that, Judge.
Okay.
Thank you, Your Honor.
Thank you, Your Honor. May we be excused?
Yes.
You have a good day, Your Honor.
Thank you. Likewise.
Bye-bye.
Okay. Goodbye. Mr. Ramos, can you hear me?
Rodriguez. Ramos?
No. You're excused, Mr. Rodriguez. I have an attorney, Mr. Ramos.
Judge, I'm sorry. I'm here.
That's okay. All right, Mr. Ramos, Ms. Trevino had asked a question. Did you have that case number for her?
Yes, I did, Your Honor. I messaged Ms. Trevino right now with that case number. It's out of County Court 8.
Okay, that'll just take me a few minutes.
Okay, let me go ahead and continue. Mr. Gomez?
Good morning, Your Honor.
Good morning, sir.
Good morning. I'm here on number 33 on your docket, and that is F054622-9, Amy Marie Silva and versus Renee Silva. And we're here before the court requesting temporary orders. And
okay,
I know that
Go ahead, sorry.
I'm sorry, dude. I was just gonna say, I know that I saw my client here a minute ago.
Yes, Miss
Oh,
Silva's there,
yeah.
and I do have someone by the screen name of Rene Silva.
I see that, yes.
Okay, Mr. Silva, can you hear me? Mr. Rene Silva, can you hear me?
Yes, ma'am.
Okay, so Mr. Gomez, have you had an opportunity to discuss this matter with the respondent?
I have not, Your Honor. He was served and I guess on the 18th or before the 18th, let me see, on the 16th. And I've not reached out to him and I've not received a phone call from Mr. Silva. And all we're asking for, Judge, is just to maintain the status quo in the temporary order. I've filed our request for a temporary order and the actual proposed order. And there isn't, but all we're asking for is that Ms. Silva maintain possession and access to her home that she's been in for many, many, many years, and her car, and that's it until we can resolve this. And I'm happy to visit with Mr. Silva and see if we can reach an agreement as far as the final is concerned. There's no minor children.
Okay.
And all we really are talking about is possession at this point of the home that Mrs. Silva has been in for 20 plus years.
Okay, Mr. Silva, do you plan on hiring an attorney, sir?
No, ma'am.
Okay, so you're going to be working this out on your own?
Yes, ma'am.
Okay. Do you have any objection to your wife staying in the home and remaining with her car?
No, ma'am, at all.
Okay, all right. Okay, so then in light of what Mr. Silva has stated also in the record, and I'll go ahead and grant the request by the petitioner and maintain the status quo. If you could please get an order to that effect, and I'll go ahead and sign off on it. And Mr. Silva, if you can please contact Mr. Gomez's office. The number should be on the documents that were submitted to you. And that way you can discuss it further as to how you want to proceed with the matter.
Okay, ma'am.
Okay.
Mr. Silva, if you'd like to jot my number, my office number down right now, I can talk to you about getting this resolved. And it is 956-662 9333.
Okay.
And I'm happy to visit with you about this. And Judge, I did file a temporary order to what we just talked about, so it should be in your queue.
Okay, then I'll go ahead and ask for that. When did you file for the divorce?
It was filed. I'm sorry that I didn't have that up. I thought I did.
On the 8th, March 8th.
March 8th, okay.
February the 11th, Your Honor.
Okay, he was just, okay, so February the 11th?
February the 11th, yeah.
Okay. What I'm gonna do is I'm gonna go ahead and set you for a final hearing on April the 20th. Just because it sounds like Mr. Silva is gonna be reasonable. And so if you're ready by that date, that's fine. And if not, let us know and we can reset you.
Okay, I'll communicate with Mr. Silva so we can have a,
Is there any way we can reset it for another day? It's my son's birthday, man.
Oh, sure. The 27th?
That'll be fine.
Okay. April 27th at 9:30.
Thank you, man.
Okay, anything else?
That's it.
Okay, well, we'll see you then. Best of luck to y'all.
Thank you, Judge.
Thank you. Okay. Ms. Trevino, any updates?
Yes, Your Honor. From the notes, the office will not be filing an intervention. We will be monitoring for the final decree. Once the final decree is obtained, the SAPSR will be non-suited.
Okay. So since they won't be filing an intervention, now that we have confirmation of that, go ahead, Mr. Ramos, if you can assist the court and have an order resetting hearing with the date of April the 20th. That'll give plenty of time for her to receive notice in the mail and for you to come up with a proposed decree. And we can finalize it on that date.
Will do, Judge. Can I get the date one more time? I'm sorry, you broke up.
April 20th?
Okay. Will do, Judge. And we already have a decree prepared. I emailed it to Ms. Flores, so we should have that all teed up before the final hearing, Judge.
Okay, sounds good.
May I be excused, Your Honor?
Yes, you may be excused. Thank you for your assistance with that.
Anytime, Judge. Thank you.
Okay.
May I also be excused, Judge?
Yes, sir.
Thank you.
Okay, Mr. Reyes, you're also excused, sir. Okay, Ms. Gonzalez, you had a divorce?
Yes, Judge.
Okay, is that ready to go?
So we have an agreement as to everything except for one dog.
Okay.
Other than that, Judge, that's why I hadn't raised my hand, but the respondent is pro se. We worked it out. We had already circulated an order, and then there's just the one remaining issue of possession of one canine.
Okay, so are there any children involved?
No, ma'am.
Okay, so yeah, pets are very special. So, Mr. Alvarez, are you going to continue to represent yourself, sir?
Yes, ma'am.
Okay, so with the respect to the issue of how many canines are there?
There are 3, Judge. My client has possession of 2, and
Okay.
Mr. Alvarez, my understanding is has possession of 1. The
Okay.
particular dog in question has been with my client for several months now, and she just feels she's a better caregiver for the pup.
Okay, well, it's up to you all. You have everything else worked out. And Mr. Alvarez, that's something that you feel passionate about?
Yeah, like I just wanted, I originally had possession of the dog in question. She asked to see her, if we could just trade one of the dogs, and then she just never returned her. I'm willing to make arrangements with her to just get visitations or to see her. But it's all up to her how she wants to proceed on the matter.
Okay, so Ms. Gonzalez, do you want me to put you in a breakout room, or do you want me to give you a short reset just so that you can have an opportunity to discuss that one issue?
No, Judge, let's do a breakout room. Hopefully we can work something out and just get it done today.
Okay, let me go ahead and do that. Okay, Ms. Gonzalez, do you want just you and Mr. Alvarez, or you, Mr. Alvarez, and your client?
Just myself and Mr. Alvarez, Judge.
Okay.
Thank you.
Mr. Alvarez, you're going to see an invitation on your screen. Please accept it.
Thank you.
Okay, Mr. Hopkins, are you here on the 11 o'clock docket?
Yes, Your Honor.
Okay, we're almost finished with the 10 a.m., with the 9:30 docket.
Yes, Judge.
All right, Ms. Martinez, you're here on F5093-21-9 in the matter of the marriage of Alejandro Hernandez versus Doris Martinez. So, Ms. Martinez, you're the respondent in this case. Is Mr. Hernandez present? Okay, unmute yourself, Ms. Martinez. Go ahead and push the button way at the bottom.
Judge John Rigney, I apologize for the interruption. I'm on a construction site. My cell phone's going a little bit low. I have a real quick uncontested matter.
Okay, CO18, is that the one with Mr. Montalvo?
Yes, and Mr. Montalvo said he was not going to appear because he was unopposed.
Okay, CO181026-I Novus Polaris versus Ricardo Diaz Rosales. Okay, what's the announcement?
Judge, I filed a third-party petition, a motion for leave to file a third-party petition. I just want to see if the court would grant that.
Okay, being no opposition from Mr. Montalvo, the court will grant it.
Thank you, Judge. That's all, and I appreciate you taking me out of order. Maybe excused.
Yes, sir.
Have a good day.
Thank you, likewise. Okay. Mr. Hernandez is on the screen, Ms. Martinez, but he can't hear me because he didn't connect to audio. So do you have Mr. Hernandez's phone number? Oh, there he is. Mr. Hernandez, can you hear me? Okay, you need to raise your volume. Hold on. Mr. Reyes. Can you hear me, Mr. Reyes? Rodrigo Reyes.
Yes.
Okay, sir, they already resolved the issue with whether or not the AG was going to intervene. You're going to come back on April 20th.
April 20?
Yes, talk to Mr. Ramos. He'll explain to you.
Okay, thank you.
Thank you. Okay. Mr. Hernandez, did you figure it out? Okay, I'm going to give him a chance to figure it out. Mr. Bergen, let's go through your default judgments.
Thank you very much, Judge.
Okay, go ahead.
The first one I have is number 12 on the docket.
Okay, CO 171382-I, portfolio recovery versus Maria Marquez. The name being called out 3 times, no response. You may proceed.
Thank you, Judge. I'm going to try to be as quick as I can to move through these, but we filed suit March 23rd, 2017. We got service April 5th, 2017. The original account was a Comenity/Bells account that was opened August 20th, 2011. Last payment date, March 22nd, 2014. And charge-off date, December 22nd, 2014. Today, we're seeking $1,222.88 plus court costs.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court since April 10th, 2017. The required amount of time has been on file for the required amount of time. So the court is going to grant plaintiff's relief as put on the record, and the order that was filed on July 10th, 2017 will be forwarded to my queue.
Thank you, Judge.
Okay, the next case.
The next is number 13.
Okay, that's CL 183360-I, Portfolio Recovery Associates versus Rosa Martinez. Rosa Martinez, the name being called out 3 times, no response. You may proceed.
Thank you, Judge. We filed suit June 19th, 2018. Service was October 9th, 2018. The original account was a Capital One account that was opened May 5th, 2007. Last payment date was June 5th, 2015. Charge-off date was January 11th, 2016. And the amount we are seeking today is judgment in the amount of $1,284.77 plus court costs.
Okay, give me one moment. Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court since October 11th, 2018. It has been on file for the required amount of time. Therefore, the court, and no response has been filed on behalf of the defendant. The court is granting the relief as requested by the plaintiff, and the order granting that was filed on May 6, 2020 will be forwarded to my queue for signature. All right, next case.
I believe it's number 15, Portfolio versus Melissa Adame.
CL 184181-I, Portfolio Recovery versus Melissa Adame. The name being called out 3 times and no response. You may proceed.
Thank you, Judge. We filed suit August 21st, 2018 and got service let's see, September 7th, 2018. The original account was a Walmart MasterCard / Synchrony Bank account, subsequently purchased by plaintiff. This was opened December 4th, 2015. Last payment date was September 3rd, 2016. And charge off date, April 9th, 2017. The amount we're seeking is $2,216.19 plus court costs.
Okay, the court is taking judicial notice of all the documents in the court's file. Specifically, the return of service that has been on file with the court since September 10th, 2018. No response has been filed on behalf of the defendant. The court is granting the relief as requested by the plaintiff and put on the record, and will sign the order that was filed on January 9th, 2019.
Thank you, Judge. I believe the next one is number 16.
CL 184272-I Portfolio Recovery versus Mirna, MIRNA, Ruco Treviño, RUCOBATREVINO. Mirna Rucoba Treviño, Mirna Rucoba Treviño. The name being called out 3 times and no response, you may proceed.
Thank you, Judge. We filed suit August 22nd, 2018 and got service August 29th, 2018. The original account was a JC Penney credit card / Synchrony Bank. That was opened February 2nd, 2014. Last payment date was January 13th, 2017, and charge off date was August 11th, 2017. And the amount we are seeking is $1,039.02 plus court costs.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court since August 31st, 2018. No response has been filed on behalf of the defendant. Therefore, the court is granting the relief as requested by the plaintiff and put on the record, set forth in further detail in the order that was filed with the court on January 9th, 2019. Okay, next.
Judge, I went out of order. The next one is actually number 14.
Okay, that's fine. CL 184089-I Portfolio Recovery Associates versus Rogelio, ROGELIO Ontiveros, Rogelio Ontiveros. Rogelio Ontiveros, name being called out 3 times and no response, you may proceed.
Thank you, Judge. We filed suit August 20th, 2018. We got service November 27th, 2018. The original account was a Home Depot account opened September 28th, 2009. Last payment date was April 9th, 2015. Charge off date was November 13th, 2015. And the amount we are seeking is $1,115.35 plus court costs.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been filed, been on file with the court since November 29th, 2018. No response has been filed on behalf of the defendant to date. The court is granting the relief as requested by the plaintiff and put on the record and set forth in further detail in the order that was filed on October 8th, 2019.
Thank you, Judge. The next is number 17.
CL 184344-I Portfolio Recovery Associates versus Raquel Peña. Okay, the name being called out 3 times and no response, you may proceed.
Thank you, Judge. We filed suit August 23rd, 2018 and got service October 9th, 2018. The original account was a Walmart credit card / Synchrony Bank account that was opened November 16th, 2016. Last payment date was December 30th, 2016, and charge off date was August 20th, 2017. And the amount we are seeking is $1,375.28 plus costs of court.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court since October 11th, 2018. No response has been filed on behalf of the defendant. Therefore, the court is granting the relief as requested by the plaintiff and put on the record and set forth in further detail in an order filed with the court on October 11th, 2019.
Thank you, Judge. The next I have is number 18.
Okay, CL 184355-I, Portfolio Recovery Associates versus Ricardo Martinez. Ricardo Martinez, Ricardo Martinez. Okay, the name being called out 3 times and no response. You may proceed.
Thank you. We filed suit, Judge, August 23rd, 2018. We got service September 3rd, 2018. The original account was a Home Depot account. This was opened January 7th, 2016. Last payment date was May 3rd, 2016. And the charge-off date was December 9th, 2016. Today, we're seeking judgment in the amount of $4,551.35 plus court costs.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court since September 4th, 2018. No response has been filed on behalf of the defendant. Therefore, the court is granting the relief the plaintiff is requesting and put on the record and set forth in further detail in an order filed on November 6th, 2019.
Thank you, Judge. The next one I have is number 19.
CL 184356-I, Portfolio Recovery Associates versus Samuel Castillo. Samuel Castillo, Samuel Castillo. Name being called out 3 times and no response. You may proceed.
Thank you, Judge. We filed suit August 23rd, 2018 and got service September 1st, 2018. The original account was a QVC / Synchrony Bank account that was opened October 5th, 2015. Last payment date, February 28th, 2017. And charge-off date, October 24th, 2017. The amount we are seeking is $657.98 plus court costs.
The court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court since September 6, 2018. No response has been filed on behalf of the defendant. Therefore, the court is granting the relief as requested by the plaintiff and set forth in further detail in an order granting filed with the court on July 15th, 2019.
Thank you, Judge. The next I have is number 21.
Okay, CL 184567-I, Portfolio Recovery Associates versus Angelica Signs. Angelica Signs, Angelica Signs. Name being called out 3 times and no response. Go ahead.
Thank you, Judge. We filed suit August 29th, 2018 and got service September 5th, 2018. The original account was an American Eagle Outfitters / Synchrony Bank account that was opened December 12th, 2010. Last payment date was October 15th, 2015, and charge-off date was May 20th, 2016. The amount we are seeking is $2,191.77 plus cost of court.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court since September 7th, 2018. And no response has been filed on behalf of the defendant. The court is granting the relief as requested by the plaintiff and put forth on the record, and is also set forth in further detail in an order filed with the court on September 13th, 2019.
Thank you, Judge. I only have 2 more.
Okay.
My next is 22.
CL 210924-I, Discover Bank versus Daniel Cepeda, CEPEDA. Daniel Cepeda, Daniel Cepeda. The name being called out 3 times and no response. Go ahead.
Thank you, Judge. We filed suit June 20th, 2018. We got service June 27th, 2018. The original account was a Discover It card that was opened June 3rd, 2014. Last payment date was June 23rd, 2017. And charge-off date was February 28th, 2018. And the amount we're seeking is $9,451.58 plus court costs.
Okay. The court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court. Oh, wait. Okay, it says that they were unable to serve her. So I guess you all meant to file a motion for substitution of service, and there wasn't one filed because they attempted service on 5 occasions.
I have a proof of service
Okay,
that was personal service on June 27th, or not, yeah, June 27th, 2018 that I have.
okay. Well, do you show that it was file stamped? Because I don't have that here. The only thing I have for June 27th, you said June 27th?
Yes, June 27th, 2018.
Okay, in this case, this petition was filed on February 26, 2021. We're talking about Daniel Zapeda, right?
Yes, I'm going to make sure, because I wrote it down, but let me make sure I was looking at the right file and I didn't screw this up. Sorry. Let me go straight into the file and see. Oh, okay. Yeah, this is, return of non-service.
Mhm.
Okay. Okay, so let me make sure here.
You'll have to file a motion for substitution of service.
Okay, Judge, I apologize for that.
So what we'll do is, I'll give you till April the 8th to file that.
Thank you, Judge.
Okay, your next case?
This is my last one, Judge. It's number 26 on the docket.
Okay, CL 193469-I, US Bank National Association versus Nazaria, NASARIA Gonzalez, GONZALEZ. Nazaria Gonzalez?
Yes, I'm here.
Okay, Ms. Gonzalez is present.
Is it possible to send me to the breakout room with?
Sure, Mr. Brogan, can I put you all in a breakout room?
Yes, Judge.
Okay, let me go ahead and do that. So you will see an invitation on your screen. Go ahead and accept it and that'll take you in.
Thank you so much.
Okay. Mr. Hernandez, did you fix your microphone? I still can't hear you, sir. Do you want to log out and log back in? Because I can't hear you. So get out and then get back in. Okay, Ms. Gonzalez, were y'all able to resolve that last issue?
Yes, Judge, we were.
All right, let me go ahead and recall that case. F4997-21-9 in the matter of the marriage of Laura Edith Alvarez and Luis Eduardo Alvarez. Mr. and Mrs. Alvarez, can I please have you each raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? So help you God. Ms. Alvarez, yes or no?
Yes.
Mr. Alvarez, yes or no?
Yes.
All right, you may lower your hands. Ms. Gonzalez, you may proceed.
Thank you. Ms. Alvarez, can you hear me?
Yes, I can.
Okay. Prior to the filing of this suit, had you lived in the state of Texas for at least 6 months?
Yes.
And the county of Hidalgo for at least 90 days?
Yes.
Okay. And you're asking this court for a divorce because you no longer get along as husband and wife, and there is no reasonable expectation that you will reconcile. Is that correct?
Correct.
Okay. During the marriage, were there any children that were born?
No.
Okay. And you are not currently expecting a child regardless of who the father is, correct?
No.
And no, as in I am correct, right?
No, as in you are correct. Yeah.
Okay. Just making sure so the record's clear. Okay. And you're asking at this time that all of the items in your possession you be allowed to keep, and all of the items in Mr. Alvarez's possession that he be permitted to keep. Is that correct?
Correct.
During the marriage, you did not acquire any real property, you didn't buy a house, you didn't buy any land, nothing like that, correct?
No, we didn't do that.
Okay, and you're asking that all of the debts in your name you be permitted to keep and be responsible for, and likewise, all of the debt in his name he be responsible for, correct?
Correct.
With the exception of a vehicle that you continue to possess, I believe that's a Kia.
No, I have a BMW X1.
Oh, I'm so sorry. I had that wrong. My notes are
It's
illegible.
okay.
I apologize for that. But that is under his name. Is that correct?
That is under his name, yes.
And the agreement is that you will continue to make all future payments on that vehicle and you must make them on time, correct?
Correct.
Okay. We had an issue regarding some pets that were required during the marriage, and you would be permitted to keep the 2 dogs named Haiti and Charlie. And Mr. Alvarez will keep the dog named Tommy, as well as any other dogs he has in his possession. Is that correct? I think he may have had some puppies.
He had, well, I don't know if he still has her, but he had one puppy that Haiti and Tommy had, but he has her.
Got it. Okay, so the dogs that we're going to identify in the decree will be Haiti and Charlie going to you, and Mr. Alvarez keeping Tommy. Is that correct?
Correct.
Okay. And do you feel that this is a fair and equitable division of the marital estate?
Yes, ma'am.
Okay. And are you asking this court for a divorce today?
Yes.
Pass the witness, Judge.
Okay, Mr. Alvarez, since you are technically representing yourself, do you have any questions of your wife? Okay, Ms. Gonzalez, do you have any questions of Mr. Alvarez?
Just briefly, Judge.
Go ahead.
Mr. Alvarez, you heard everything that I asked of your wife. Is that correct?
Yes, ma'am.
Okay. And are you in agreement with the division of the debts and assets, including the pets?
That's fine.
Okay. And are you asking this court to grant your divorce as well?
Yeah.
Thank you, Judge. Pass the witness.
Okay. Did you say is Ms. Alvarez having a name change?
I did not, Judge, and I actually don't have that in my notes before me. Ms. Alvarez, are you requesting this court to change your name back to your maiden name?
Yes, ma'am, please.
And what is that full name?
It's Laura Edith Meade, M-E-A-D-E. Yes.
Okay. And you are not currently pending any kind of criminal indictment or criminal charges, correct?
No.
And you're not asking this court for a name change to avoid any creditors?
No.
Thank you. Judge, we would request that amendment, please.
Okay, so the court will grant your trial amendment and allow and grant her name change to Laura Edith Meade, M-E-A-D-E. The court is also going to approve the agreement as read and testified to on the record by the parties. And the court is granting the divorce today. So how much time do you need to submit that decree?
Judge, we had already circulated it for signature. I need to put in, I believe, that one language change on the dogs, and then we can send it out. If the court will allow us for e-signature, we can probably get that e-filed by the end of the day, Judge.
That's fine. I'm gonna just set a tickler for myself for April the 8th.
Okay.
Okay. All right. Well, best of luck to both of y'all. Y'all are excused.
Mr. Alvarez, I'm going to go ahead and make that amendment, and then I'll send it to you for signature. Can I just get your email on the record, please?
It's Luis E. Alvarez 3@gmail.com.
Okay, so the same one that we've been communicating on, right?
Yes, ma'am.
Perfect. Okay, thank you so much, sir.
Thank you.
Thank you, Judge.
Thank you. Y'all have a good day. Best wishes to y'all.
Thank you, likewise.
Thank you, you too.
Okay, so Mr. Hernandez, did you get it fixed? Go ahead and unmute yourself and see if it fixed itself.
¿Ahí me escucha?
Yes. Oh.
No, no hablo inglés, hablo solo
Okay.
español.
Ok, está bien. Ms. Martínez, ¿usted habla inglés o español?
Español también, por favor.
Ok. Ok, ¿ustedes tienen un hijo de menor de edad?
No, ya no. Ya tiene ya cumplió 18 años.
Ah, ok. So, entonces, ¿ustedes tienen hijos menor de edad o no?
No.
Okay. ¿Y tienen bienes?
Una propiedad en común, una
Okay.
casa, un terreno. Ajá.
Okay, we do not have any minor children. We have one property of the community estate. ¿Qué es la dirección?
4509
4509.
Heaven Lane, en Edinburgh.
Okay. No, ¿me lo pueden deletrear, por favor?
Es 4509 Heaven como cielo.
Oh, Heaven Lane.
Heaven Lane.
4509 Heaven Lane in Edinburgh, Texas.
Correcto.
Es porque no lo incluyeron en su petición.
Oh, ok.
Y déjame ver. Ok. So, sí, entonces, ¿es la única cosa que tienen en común?
Sí.
Ok. ¿Y carros?
Ella tiene el propio de ella y yo el mío.
Ok, pero ya se deben en esos carros.
No. Al menos en el mío no. La camioneta que tenía cuando estábamos juntos, ahora la usa mi hijo.
We each have our own vehicles. They do not have debt, or at least they didn't when we were together. The vehicle I had while we were together, my son now has it. Señora Martínez, la camioneta que usted tiene se debe.
No, pues porque la trae mi hijo, la que teníamos en común, él y yo, la trae mi hijo ahora, y esa camioneta no se debe. Yo tengo la mía personal, pero la saqué hace unos meses apenas.
Okay, so the vehicle that we had in common, my son has it. And so it's not owed on. I have a vehicle that I took out a few months back, but that's my vehicle. It's my separate vehicle. Okay, lo que ustedes le faltan aquí es el decreto del divorcio. So, necesitan que ustedes lo tienen que firmar y no lo tienen aquí. Yo no le puedo decir dónde hallarlo porque la ley me prohíbe a mí de darle ningún servicio legal.
Okay.
So, no le puedo decir dónde sacarlo. Yo creo donde ustedes fueron a sacar esa petición, a lo mejor ellos, pues ese mismo local le puede dar el decreto. What I'm explaining to them is that I cannot give them any legal services. They do not have a final decree of divorce on file. Maybe where they were able to secure this original petition for divorce, they also have an example of a final divorce decree. So, ustedes necesitan que hallar ese papel y firmarlo. You all need to find that paper and sign it. So, les voy a dar otra fecha. I'm going to give them another date. Van a regresar el día 27 de abril. You will return on April 27th a las 9:30 at 9:30.
Ok, gracias.
Y de para ese tiempo, por favor, tengan ese documento, si no, no se van a poder divorciar.
Okay.
By that time, please have that document or else you will not be able to get a divorce.
Ok, entendido.
Ok, muchas gracias.
Muchas gracias a usted.
Okay, thank you, and thank you. I feel like I was talking to myself. Okay. All right, let's go ahead and now we're moving on to the 11 a.m. docket.
Your Honor.
Yes.
I'm sorry. I have a quick announcement, Judge.
Sure. Did I miss you on the other one? I'm sorry, go ahead, Mr. Cisneros.
I was on number 10 on your civil docket, Judge, this morning.
Oh, that was Mr. Sabo. I think he had stated that you weren't able to come on and he made the announcement. And so we reset you to March the 30th at 9:30.
Okay, great, Judge. That's all I wanted to confirm was that the hearing didn't get, in fact, reset.
Yes, he said you were unavailable this morning and if we could have a quick reset.
Okay, sounds good, Judge.
Okay, sorry you had to wait that long,
No problem,
but
Judge.
I hope I entertained you with my translations.
Thank you,
Okay,
Judge.
have a good one.
Yes, ma'am. Bye-bye.
Okay, now we're moving on to the 11 a.m. docket. Let me recall CL 21935-I, Leticia Ibarra versus CCRGB Pizza Inc. et al. Announcements?
Yes, good morning, Your Honor. James Sadia, on behalf of the plaintiff, Leticia Ibarra. Judge, I believe this matter had been set for hearing last February, and I believe we worked out all the issues. I amended my petition, and my understanding was that I didn't know the motion was still being urged today.
Okay.
I assumed it was just a status hearing to see what the status of the.
Mr. Red, is that the one that you're on, Mr. Red?
Yeah, yes, Your Honor.
Okay.
The motion that was carried forward was one brought by Cece's Pizza. We represent my firm, Architera.
Okay.
We received notice that from the court that the matter was being carried on forward and to be heard today, I guess for status purpose. And so
Okay.
we're here.
So who's representing CC's Pizza? Okay.
I have to go back and look real quick, Judge.
Well, I have a John Engvall, but perhaps, I don't know, I mean.
I'm with Engvall in York.
Okay.
That's our firm.
And then there's a Scott Kinzel.
Yes, and this motion for summary judgment was as to CC's, Judge.
Okay.
That we did file a response, we did hold a hearing, and I believe those issues have been
Resolved. Then I'm not
yes.
sure why they may have filed an order resetting hearing and that's why we had submitted it, but what's the status on it since they're not here to urge it, so.
right. Yeah, and I think that this today was a status because they weren't here to urge it. No, Judge, I've had good communication with the attorney for CC's, and I'm optimistic that we'll be able to come to some sort of resolution sooner than later.
Okay, so have you all already concluded discovery so that you can go to a mediation?
No, ma'am, we have not. We've done some preliminary discovery. We just need a little bit more. We're hoping to take the depositions of several of the parties involved, and from there we should be in a good position to mediate.
Okay, let's go ahead and set it for a status for June the 8th.
June 8th.
At 9:30. And if you can mediate it before then, great. And if you need a referral for a mediator, just submit that order of referral and we'll get somebody assigned.
Yes, ma'am.
Okay, anything else?
Nothing further from the plaintiff, Your Honor.
All right.
Thank you so much, Your Honor.
Thank you, ma'am.
Thank you. Thank you for your patience.
Yes, ma'am.
Okay, Mr. Hopkins, are you here on the case with Mr. Pruneda or in a separate case?
I'm on the Pruneda case, Your Honor.
Okay. CL 186390-I, Angelita Pruneda et al. Versus Gregory Funding et al.
Good morning, Your Honor. Mark Hopkins on behalf of Gregory Funding and U.S. Bank. This is my
Okay.
motion for summary judgment.
Okay, Mr. Pruneda, were you going to be arguing for yourself today or was Mr. Rayfield coming on?
I was going to be arguing today. I think we both had some health issues. He wasn't feeling well a few days ago, and I talked to him briefly yesterday. He was still somewhat under the weather, and I myself was in the hospital 2 weeks ago for a full week with kidney stones, and I'm under medication right now. I'm trying to get around a little bit, but I'll do my best, Judge.
Okay, all right, Mr. Hopkins, this is your motion, so go ahead, sir.
Yes, Your Honor. Before we get to the motion, we filed a motion to strike the Pruneda's amended petition that was filed 2 days ago. So I'd like to address that motion to strike first, Your Honor. This
Okay.
lawsuit,
Go ahead.
the Pruneda's filed this lawsuit back in 2018. We filed our motion for summary judgment in October of 2020. The summary judgment motion was set for hearing on February 22nd, 2021. The Prunettas got continuances from that setting, as well as from additional settings for June 14, 2021, July 26, 2021, October 27, 2021, March 7th, 2022. And now the matter is set for today, Your Honor. So despite having 4 years and 5 previous summary judgment settings, the Prunettas waited until 2 days before this summary judgment hearing to file an amended petition. Texas Rule of Civil Procedure 63 requires pleadings to be filed 7 days, at a minimum of 7 days in advance of trial without leave of court. A summary judgment is considered a trial under Rule 63. As a result, the Prunettas' amended petition is untimely and it works a prejudice upon my clients, and we request that it be struck.
Okay, Mr. Pruneda, your
Well,
response?
Your Honor, given all those resets, and I think the court is aware of that, not only do we have the 2020 pandemic, which was out of everybody's control, but also in March of 2020, we were personally, and my wife were hit with some very tragic news that by the time she was, even though she'd been under examinations for about a year, it took about a year for the doctors to realize that she had a late stage 3 double breast cancer, which required that she go to MD Anderson, and I had to take her during that entire time up until just about 3 weeks ago that she finally completed treatment. She did undergo a radical mastectomy on both breasts because of the cancer. It's finally under control. And that's only been as recent as about, like I said, about 2 weeks ago. She's not out of the woods yet, but they're giving her a high probability that she will survive, as opposed to the way it looked in 2020 and even the latter part of last year. So obviously it was not on the basis of delaying this case, but rather something that was strictly out of her control. It was a medically necessary request that we made of the court because it was either her life or attend hearings and attend to my business at the office, Judge. This was not the only case that I asked the courts to indulge me and reschedule hearings. I have to state that all the judges were very considerate, and I appreciate all of you. But again, it was something that was not within our control, and we just could not miss any. She was under a very tight regimen because every day was going to count toward either losing her life or having a chance of living. So that's one. And secondly, Judge, I filed this petition not knowing that Mr. Rayfield, and I'm not putting this on his back. I just was not able to communicate with him as often as I should have because of the time that I was spending up at MD Anderson and having to take instructions from the doctors on how to apply some of the treatment plan at home once we brought her back. The radiation was 5 days a week, Monday through Friday. And the only time we would come home would be on the weekends to spend some time with our daughter. So I filed a petition knowing that under Rule 63, I should have asked the court for leave of court. But given the circumstances, I think that there is the basis for an excuse versus an intentional or conscious disregard for the rule, Judge.
Okay, so first of all, the motion to strike on the defendant's motion to strike is not set today. It's was filed on March the 21st. You need to file an order setting hearing on that. And then Mr. Pruneda is entitled to 3 days notice. And then of course, so we do need for Mr. Hopkins, I do need for your office to please file an order setting hearing on your motion to strike, and we'll get that set. And then we can take it up at that time. But so I want to proceed forward with the motion for summary judgment arguments. Mr. Hopkins?
Yes, well, the motion for summary judgment directly ties into Mr. Pruneda's amended pleadings. For 4 years, Mr. Pruneda has argued that he has a loan agreement with my client, and but for my client working with him more diligently to cure his default on his mortgage, which has existed since 2010, that my client should be prohibited from moving forward with foreclosure. I want to be clear, Your Honor, in a related case, my client already has an agreed judgment for judicial foreclosure. It is not final because Mr. Pruneda has sued other parties in the litigation, but I'm not asking for foreclosure in this case. Mr. Pruneda filed this lawsuit after that agreed judgment, claiming that we haven't given him the opportunity to cure his default under the contract. Our summary judgment is very simple. The contract specifically requires that we are to give Mr. Pruneda a notice of default. It specifically sets out how we're to give him that notice of default. Texas Property Code Section 51002 tells us when and where and how we're to send that notice of default. So our summary judgment evidence responding to his singular claim that we haven't given him the opportunity to cure is in fact the notice of default with the opportunity to cure that was sent via regular and certified mail back in 2013 to the property address to Ms. Pruneda because she is the sole obligor on the debt. So to the extent the Pruneda's pleadings previously asserted a single cause for a breach of contract based on lack of notice, that fails given the undisputed summary judgment evidence of the notice of default mailed in compliance with the deed of trust and Texas law. Since then, Mr. Pruneda has amended his pleading, and now he says, well, maybe we don't have a contract at all. And what the bank is trying to do is now foreclose under an illegal mediated settlement agreement. That's not our petition, Judge. I don't need that foreclosure order. We're not asking this court to grant us an order under any mediated settlement agreement. It's just a matter of diversion, distraction, and delay that we've been dealing with repeatedly for years and years. I'd request that the court grant summary judgment dismissing the Pruneda's breach of contract claim with prejudice. That would leave my remaining counterclaim that we've sought damages for his breach of a settlement agreement in other litigation. It's extremely likely if this court were to grant our request to dismiss his breach of contract claim, Your Honor is likely to hear me next utter the words that I am taking a non-suit without prejudice with respect to my counterclaim so that the judgment in this case can become final.
Okay, Mr. Pruneda, your response?
Your Honor, again, unfortunately, when this loan had been taken, it was not taken, well, it was taken, I guess, shortly before my personal history on my cancer, which took 10 years to resolve. But putting that aside for a second, Judge, we have to rely on what the case law and the opinion in Geiselman versus Kramer Financial Group, which is cited as 965 Southwest 2nd 532 Court of Appeals of Houston 14th District. Judge, the affidavit that the movements have relied upon, it was an affidavit by Amy Furpo, whom I do not know. And unfortunately, this affidavit, even though it details a lot of history on this particular loan and case, under that opinion of Geiselman, Judge, it's very clear what the Court of Appeals said, that the affiant must have personal knowledge, or they must get the affidavits of the individuals who were part of that negotiation at the time, and that the documents were prepared as a result of their personal knowledge and involvement in the case. This is a case law opinion, Judge, and that's more so in pages 537, 538, and 539 of that opinion, that merely stating some facts and that they're familiar with, say, the history or the documents that are kept in the regular course of business by one of the entities saying the loan, especially when it's a note that is transferred from one borrower or one lender to another lender to another lender, or a servicing agency. that the affidavit must be made by a person who has personal knowledge of the events and the documents that were prepared and the signatures were made at the time that the documents were prepared. And all we want, Judge, is for us to be able to develop some, now that our lives seem to be getting back in order, I've beaten the cancer that I had, which was esophageal cancer. My wife looks like she's beaten the cancer at this point. Our lives can kind of get back on track. Prior to the personal medical history, Judge, we had a very good payment history. Matter of fact, when I bought that house, that property, back in 1981, it was owner financed. I had a 15-year note and I paid it off in 6 years. I'm used to paying my debts. My father, my mother taught me that. However, when you're faced with events that are life-threatening and totally out of your control, and you wake up one morning and you're given a diagnosis, it's not something that we are always prepared for. The medical expenses on my part, depleted all my finances. I was worth over $5 million at the time. I beat that. I paid off the medical bills and everything. Then as we were getting on our feet again, my wife gets struck with cancer. I don't know if it's just a location or what, but nonetheless, our daughter's now working. She's able to apply for a loan on her behalf. She's single, still lives at home. And she's more than willing to step up to the plate and assist. My wife is retired already. Even if she were not, she would have had to retire because of the cancer. But between all three of us, I know that we can get back on track. It's always been our intent to pay whatever we owe. But if on just a legal basis, Judge, on that affidavit, I read it twice, and I read it again this morning, that the language that is contained is contained in that affidavit by Ms. Furpo is insufficient according to the Geisselman opinion, Judge. It must have, because it's a hearsay over hearsay, Judge. So we know that under the rules of procedure, if this were a trial or a deposition, a hearsay statement that's based on hearsay cannot be admissible. Therefore, the affidavit is insufficient to support the movement's motion for summary judgment. And just on that basis alone, Judge, the court should have a basis for denying the movement's motion for summary judgment. And the opposing counsel says that they're not even asking for an order of foreclosure at this point. Now, he knows as well as the court knows that if the court were to deny their motion for summary judgment at this stage, we can still go through some at least basic discovery, flush out some of the issues, and perhaps at that point, even allow me a chance to start getting things in order to see what I can do. I've got 2 acres in sale right now. I've talked to a private buyer who's willing to buy them cash. I have not had them appraised, but I will have, or the buyer will have them appraised. They're free and clear. And so that alone, because of the location, is enough to pay off the note and leave some money to pay off the medical bills that my wife has recently incurred over a year and a half. So it's just a matter of asking the court to not only interpret that affidavit as being insufficient, because according to that opinion and the guys, it does appear in its face that it is insufficient. And it also appears, like I said, that it's hearsay upon hearsay, which not be admissible. And then with the time that we've had to go through this medical issues, that we are now finally seeing some light at the end of the tunnel, I know that we can bring this matter under control and afford me the opportunity to do what I've always done in the past before I've had any health issues, which is pay my debts, pay them on time or ahead of time. Most of the time I try to pay them ahead of time. And so I'm asking the court to look at that affidavit by Ms. Furpo, look at the opinion of Geiselman, and I think the court will be more than convinced that my position is correct. And the court should deny the movement's motion for summary judgment at this stage. They're always free to file again, if necessary, after some basic discovery. And with that said, go ahead.
Okay, Mr. Bruneta, anything else before I allow Mr. Hopkins to reply?
No, I'll see what he has to say, Judge.
Okay, go ahead.
First of all, Your Honor, Gregory Funding and U.S. Bank is not indifferent to the Pineda's health plights. This loan has been in a state of default since 2010. While irrelevant to the actual legal argument made by Mr. Pineda and his evidentiary objection, the reality is that Gregory Funding and U.S. Bank have bent over at every turn to help the Pinedas. The Pinedas have not attempted to repay their debt. In fact, they have had 3 prior home equity loan expedited proceedings set aside. They took an agreed judgment in a prior lawsuit for judicial foreclosure, and they were given a loan modification and a settlement agreement, which they refused to sign. There was $45,000 in the other court's proceeding, another court case pending to go towards payment of the debt. The Pinedas improperly submitted an ex parte order and withdrew $45,000 from the court's registry, which the court, after being made aware of that, set aside that order, and the Pinedas have yet to repay that. So while I have every sympathy for their health concerns, as a litigator, I take extreme issue with the conduct in the past case. All I hear in this case is Mr. Prueda arguing, not that my argument about notice of default is wrong, but that my summary judgment evidence is deficient because my business record affidavit is deficient. And he cites us to a Houston Court of Appeals case that he's read. Your Honor, I'm not going to rely on a case that I've read. I'm going to rely on the hundreds of appellate decisions that I have personally obtained from every intermediate appellate court in the state, the Texas Supreme Court, and the Fifth Circuit on this issue. I would direct the court to my reply, specifically Roper versus City Mortgage. It is apparent from Roper, and the case is cited in my motion, that a witness can obtain personal knowledge to prove up business records if their relation to those records is explained. In this case, we have a custodian who says she's the custodian of records. She says, I have reviewed my client's records. My client obtains records from prior mortgage servicers and incorporates those into our records and relies on those records. And that testimony alone, Your Honor, is sufficient. I'd refer the court to Simeon versus Unifund out of the Houston Court of Appeals, the First District, where the Simeon Court says a document authorized or created by a third party may be admissible as a business record of a different business if the document is incorporated and kept in the course of the testifying witness's business. The business typically relies upon the accuracy of the contents of the document, and the circumstances otherwise indicate the trustworthiness of the document. And then I point out the Roper case, Your Honor. That's a case I handled out of the Austin Court of Appeals. Petition for review was denied by the Texas Supreme Court. And in Roper, the Austin Court of Appeals held the following. The rules of evidence do not require that the qualified witness who lays the predicate for the admission of business records be their creator, be an employee of the same company as the creator, or have personal knowledge of the contents of the record. And then the Austin Court goes down to explain in its opinion that a subsequent mortgage servicer can certainly take the records of a prior servicer, incorporate them, and authenticate them. So on that basis alone, the deed of trust and the assignments attached to our summary judgment should be admitted. Those documents are also self-authenticating under Rule 902(8), dealing with acknowledged documents, as the documents are notarized. Notarized documents are self-authenticating under Rule 902(8). The Roper Court also held that. So the deed of trust and the assignments are self-authenticating. The note and the notice of default, well, actually there are two. The note is obtained from the prior mortgagee. That can be authenticated by our mortgage servicer. The other is the notice of default. I don't know what Mr. Pineda is thinking. Maybe he misread the record. The notice of default didn't come from anyone other than Gregory Funding. That is our own self-created record. And certainly our custodian can prove up.
Okay, I'm sorry, I was getting some feedback, but go ahead.
Certainly our Gregory Funding's custodian of record can prove up Gregory Funding's own notice of default. And our summary judgment is based upon our notice of default and the deed of trust, which is self-authenticating. If the court wanted to strike every other exhibit, I don't believe it would be proper. It wouldn't affect the merits of our motion. The deed of trust is self-authenticating, and the notice of default is our client's very own document. As for Mr. Paredes' suggestion that he should be given one more chance to bring this note current, Your Honor, he stabbed us at every turn, and we've been talking about this for 12 years now. It's time to bring conclusion to this case. This case is nothing more than an impermissible collateral attack on that prior judgment for judicial foreclosure.
Okay,
In
so
response, Your Honor.
go ahead. I mean, we're running short on time, but go ahead.
Okay. Very quickly, Judge, I'm going to proffer the arguments and the response that we made in writing and to the motion for summary judgment, particularly on the issues of holder and due course and the holder of the note, production of the stating that they have the original note on file in their possession, and they are in fact acting on as proper assinees to the note. And the arguments we've made on paper, Judge, in our response that was filed with the court and the cases and the allegations or the arguments we made therein is what I proffer at this point in response to opposing counsel's most recent argument, Judge.
Hold on. Okay, so I'm not going to strike any of the exhibits. The exhibits are all that, and I have gone over this very thoroughly because this is very serious. What I wanted to ask you before we proceed, Mr. Hopkins, you're located in Austin?
I am, Your Honor. I have a statewide practice.
Okay.
I live in Austin.
Okay, so would you, do you have any trips down to the Valley soon so that I would like to staff this in chambers? I don't want to really do it via Zoom because sometimes we get things lost in translation. Would you be available to come down sometime soon?
Yes, Your Honor. We certainly could be in
There's
your courtroom anytime Your Honor requests.
Okay, so at this time, I've heard all your arguments and I've read all the pleadings. I read them the first time that you were said, and I do understand both sides. And my job is obviously to be the fact finder in this situation, but it's also, and then I see both sides, okay? However, I do know that there does need to be some type of resolution in this case. Either, it's going to end with the summary judgment being granted or it's going to go forward. But I feel that perhaps because my practice also for almost 15 of the 20 years that I was in private practice was also in mediation. So somehow I may offer a different perspective, but I would like for the parties to come together and I would like to meet with everyone before I issue a ruling. So if you all can indulge me with that, I can certainly set a time that is convenient for Mr. Hopkins or Attorney Shelley Hopkins to come down, since you all are the ones that will be traveling.
Yes, Your Honor.
What is a day that you would prefer? Would you prefer a Thursday or Friday? I know, or I think it's easier for you all to come down. Something like that. I mean, I'll work with your schedule.
No, Your Honor, something, before COVID, I could have told you the flight schedules in and out of every city in the state.
I know.
I don't know the flight schedules currently, but I'd prefer not a Monday or a Friday. So those tend to be the most hectic airplane days.
Okay.
And any setting on a Tuesday, Wednesday, or Thursday midday that allows us to come in the morning and leave in the afternoon would be more than agreeable.
I agree with
Appreciate
that.
the court accommodating us.
Okay. I would like, right now, what I would like to do is just so that I can give you some time to get a flight. And so I don't know, is April 12th too early?
No, Your Honor, let me,
Why don't you check your schedule?
yes, Your Honor. One
Mr.
moment.
Brunetta, are you available in the afternoon of April 12th?
I'm asking my secretary to bring my calendar, Judge. Give me just a moment, please.
Okay. I can also do the 5th if that's not too early for you, Mr. Hopkins.
No, Your Honor, it's, and Shelley Hopkins is my wife, so we have a and the other Hopkins is my triplet brother.
Oh, okay.
So there are 3 Hopkins, and we've all done mortgage litigation for decades. If I could get my calendar.
I didn't want to assume she was your wife or maybe sister, cousin, you never know.
Yes, Judge.
Okay, Mr. Brunetta, do you have that calendar with you?
She's bringing it to me right now, too.
Okay.
Okay. Good minute. Okay, yeah. Okay.
Can you check your calendar, Mr. Brunetta, for April 12th?
April 12th. Do I have anything April 12th?
Your Honor, I'm set for a multi-day trial in San Antonio starting the 11th, but the 5th I have available.
Okay, look at April 5th.
Okay. What's April 5th look like?
It's a Tuesday, correct?
Yes.
You don't have anything for April 5th. Okay. It looks like I'm open April the 5th at this point, Judge, and then also on the 12th.
Okay, let's go ahead and do April the 5th at 3 p.m. in my chambers.
Okay.
If you can please tell Mr. Rayfield if he's going to want to join us. And
It's April 5th.
we'll go ahead and that Mr. Hopkins and Mr. Brunetta is on the 3rd floor.
Mhm.
When you get off the elevator, you'll take a right and then take another quick right, and you'll see the offices of County Court 9.
Okay.
And that'll be on April the 5th at 3 p.m. for a staffing.
3 p.m. Okay, very well, Judge.
Okay?
Yes, sir. Thank you. Thank you very much. Yeah,
Okay,
thank you,
and
Mr. Hopkins.
I'll see you all then.
Have a good day.
Thank you.
Excused.
Yes, thank you. Okay, Mr. Brogan, thank you for your patience, and thank you, Ms. Gonzalez, for your patience. I'm going to recall that case. If I can find it. Okay, there it is. CL 193469-I, U.S. Bank National Association versus Nazaria Gonzalez. And what is the announcement, Counselor?
Judge, we didn't settle yet, but Ms. Gonzalez has sent us a settlement offer. I've submitted it to my client. I expect her response soon, but if we could have a 60-day reset, hopefully we can get an agreed judgment in before.
Okay, what other day did I give you to come back? May the what?
Let me look. May 27th was a court reminder date.
Yeah. Oh, I thought I had given you a day. Yeah. No, okay, let's, then we can do 60 days, that's fine. And we'll do May the 25th.
Okay, Judge, and would that be at 9:30 a.m.?
Yes, sir.
Okay.
Or we'll attempt to do it at 9:30.
Okay.
Okay, anything else?
No, that's all I have. May I be excused, Judge?
Let me just get an email address for Ms. Gonzalez. Ms. Gonzalez, what is your email?
It's nasariagonzalez@yahoo.com.
Okay. And do we have your name spelled correctly? Nasaria, Nazaria?
Yes.
Gonzalez, Gonzalez?
Yes.
Okay. All right, then May 25th at 9:30, Ms. Gonzalez.
Okay, thank you so much. May I?
Okay. Yes, you may be excused. Mr. Brogan, anything else?
That's all I have. Thanks, Judge, for all the help. I appreciate it.
You're
Thank you.
welcome. Have a good day.
Have a good day. You too.
Okay, on number 36, did they call in?
No, Your Honor.